for listing.
Listing.
Please give it there.
Date বিলাক মই
Item 1.
adjournment আছে নি?
Adjournment 2019 later allowed, earlier not allowed.
Lordship, the parted matter
Sorry.
item number, the parted matter item number 26, Lordship. The government come up with a proposal, Lordship. This
We'll
downtown.
see. Let the item be called. We'll hear you.
Item 1 for motion with personal appearance.
Yes, what did you get?
My lord, they have made a skill verification, my lord.
Ki pale?
Sir, namaskar.
Namaskar. Ki pale?
Sir, honorable court or sir instruction অনুসৰি আমি sir field visit গৈছিলো sir.
Pale ki?
হয় sir.
তেওঁলোক বৰকছাৰী হয় নে নহয়?
Sir, বিভিন্নজন senior citizenৰ লগত কথা পাতিলো sir, তেওঁলোকৰ মতে
কি কৰিলে সোধা নাই, হয় নে নহয়?
sir supportive document নাপালো sir.
নহয়। তেতিয়াহ'লে you have to go by there. It's a medical admission.
My lord.
Medical admission. Where is Mr. Gogoi? Do one thing. Subject this person. Where is Mr. Aram Das? It's your department. Let the person appear before the committee today itself. The President, Vice President, and the Additional Deputy Commissioner will also remain present. They will provide the committee with the relevant material what they have. Petitioner will also appear, say whatever you have to say. And the committee will submit a report to us by tomorrow. Tomorrow is the last day. There is no other way out.
Today in other matters, committee is supposed to.
This drastic approach has to be followed because
My
there is no other way out.
From my part, tomorrow, my lord, I may not be available, my lord.
We are not concerned with who is available, who is not. Today, the candidate will appear before the committee. The Additional Deputy Commissioner and the Vice President of Sangha will also remain present. They had made an inquiry. They will provide their materials before the committee. Committee will take a final call, submit a report to the court tomorrow.
My lord, the time today when the petitioner will come.
Today, right now. Immediately, ask the petitioner to go there.
No, my lord.
And or else, Mr. Sorania, your petitioner will become infructuous. You will not get any benefit. Choice is yours.
May I submit, my lord? Then I'll proceed my case, my lord. Yes.
See, only determination to be made is whether the person having surname Sorania in this present case belongs to the Borokosari community or she does not belong. Law says it is the special committee who is the ultimate authority to take a call. We had made a preliminary inquiry through the Additional Deputy Commissioner and the Vice President. Their report is before us. They say we cannot say that the person belongs. Only option for you is to the committee. If the committee says you belong, we'll follow the committee. We'll get it. If the committee say you do not belong, consequence you face it. This has to be done today because tomorrow we need the report for passing our order. 30, there's a holiday for the court. Courts will not be sitting. 30 is the last day. Even if I delay by 1 or 2 hours also, the matter will become infructuous. So you have no other option of making any other submission.
No, my lord.
Because we are not going to decide whether you belong or you are not going to
Let them
belong.
decide it, my lord, according to the, no, maybe my lord early, but not by, because this client who is the petitioner now in the college, my lord, attending classes. So I have to inform her, my
if
lord.
you don't cooperate, you don't.
I was going to definitely cooperate, my lord.
Don't,
So,
Mr. Sorania, please don't raise a.
Lordship,
raise
bear
a
with me, my lord. He
Mr.
sees
Saranya,
Nogao.
Mr.
At least 2-3
Saranya.
hours will be required.
Mr. Sorania, don't begin the morning with an argument and raising voice, etc. We are giving an option that is the best possible option, I think. Mr. Dhor, can you think of anything else? Mr. Gogoi, can you think of anything else?
My lord, the girl, my lord, the petitioner, she is attending classes. I have to inform her. She has to come down from the Nogao to Guwahati.
From?
Nogao to Guwahati. She is attending classes.
Okay, at 3 o'clock.
Because I have to
Enough
inform
time
right now.
Nogao 5 hours is enough time to come. 3 o'clock.
Even, my lord, that information can be given by the learned council of the health, my lord, to the principal of the
They'll do it. Medical department is fully cooperating. that social justice department or the tribal welfare department is also fully cooperating. The officers and the Sangha people are also fully cooperating. So it's now up to you.
My lord, may I proceed with my case, my lord? Because my lord,
You
they
don't
have
want
the-
to do it. Argue.
my lord, because they have the
Yes,
massive
please
village,
argue.
my lord,
Please argue.
my lord. Because my the village, my lord. the
We don't want
petitioner,
any.
they're
We don't
having-
want any
they're
reason.
fully, my lord, it is scheduled tribe village, my lord.
Do it.
So they are only, my lord, finding out the, my lord, family tree, my lord. Basically, tribal people do not preserve the family tree, my lord. Up to grandfather, grandfather, they can, my lord, speak. So they are not preserving,
Mr. Saranya, please don't waste time. Start with your submissions
my lord.
because we have many other matters to take up today. Yes, two officers, you also please remain present.
My lord, the petitioner certificate, my lord, annexure 3, page 20, my lord. The issued by the authority, my lord, by the Tamilpur District Tribal Sangha, signature put by possibly Vice President, and it is authorized by the Sub-Divisional Officer, my lord, Tamilpur, my lord. So, my lord, thereafter, on that basis, my lord, when the, my lord, the petitioner appear in the NEET, my lord, qualified, my lord, in the scheduled type reserve quota, that for, my lord, annexure, my lord, they put the signature, my lord, page 26. Later on, my lord, immediately after issue, next day, my lord, the landed additional deputy commissioner, my lord, that concerned deputy commissioner, my lord, asked to return the death certificate, my lord. But I keep one photocopy, my lord. That I approach the honorable court to give me either fresh copy, then court pass an order by this photocopy, the provisional admission, my lord. Then lordship matter is this, my lord. Basically, my lord, the her title, though it is Soronia, my lord, they belong to scheduled tribe, my lord. But his
Give them a chair also, both of them. Yes, please continue.
my lord. The basically Soronia, my lord, is not a such kind of recognized tribe, my lord. That is true, my lord. But due to, my lord, conversion to the Hinduism, the tribal basically Bodo and Ravas, my lord. Some people are used to write, my lord, common title which are commonly used by the Assamese people, my lord. But since the day of independence, my lord, when it was notified the Bodo Kosari or Rava, they are only the status, my lord. And this status, my lord, arises when some of the doubtful candidate used to take on the name, my lord, other non, my lord, the tribal title, my lord, which are used by the commonly used by the Assamese, my lord. The doubt created, my lord. Therefore, there is a direction from the tribal Sangha 2003, my lord. So, who are belong to Bodo and Rava community using the uncommon title used by the tribal or used by the common title by the Assamese community, they are to be, why issuing the certificate, they should be strict and they should be required to be, my lord, take care of it. That's why tribal Sangha decided to take a decision, all these kind of people to write Soronia, my lord, so that one unique formality would be, my lord, there will be no difficulty in issuing. Some of them, my lord, this who are, my lord, by religion Soronia, they have changed the title, my lord, to Soronia, my lord. Some are using still Das, Deka, Soikia, Borua, my lord. But in case of the other type, but Sonwal Kosari and Thengal, there is no dispute, my lord. Sonwal Kosari also using their my different title, Bora, Soikia, except Sonwal, my lord. Different title. Bora also. Bora is commonly used by the other Assamese people, my lord. In case of our Boro also, my lord, two title is not belong to Bodo, my lord. Even then, they have been accepted by the society. This Soronia title also has been accepted by the society. Either he may be Rava or may be Boro, my lord. So, my lord, the village, the petitioner belong to which, my lord? Phokotpara. Completely, my lord, tribal people. My lord, additional deputy commissioner will understand, my lord, only because they are doubting regarding the titles, my lord. And in case of land record, my lord, if you go to the land record also,
we don't go. We are not expected to go and verify some land records somewhere.
but that's why if they want to justify the records, my lord,
mind your expressions also, Mr. Soronia.
my lord.
Please continue.
So, my lord, this is the history, my lord. This Soronia is not any tribe, my lord. Because of, my lord, this title, and thereafter, my lord, one case was filed in the Guwahati High Court when the, my lord, Nobokumar Soronia has been contested in the election as a scheduled tribe candidate who has been elected, my lord, still he is representing the Kokrajhar Parliamentary Committee. Because of this, his, my lord, that issue, that, my lord, some, my lord, people are doubting those titles, my lord, whether he is belong to Rava or, my lord, Boro Kosari. Basically, Soronia, who used to write the
Understand,
title, Rava and Kosari.
So now, what is your submission now?
The submission, my lord,
Background to be understood what you said.
My lord.
Now, what is your submission?
my lord, so, my lord, my submission is that suppose they are belong to Boro or Rava, my lord. They are now want to, my lord, bifurcate because of this problem. Still, they will remain, my lord, Boro Kosari. Because there are so many proposals, my lord. Some are, I am not claiming as a Soronia, my lord. But some are people who are converted to Hinduism, my lord. So,
Yeah, you are repeating third time. The convert to Hinduism, you are repeating for the third time. Please proceed ahead so that we can understand your
no,
case.
my lord. Those,
Mr. Soronia,
my lord.
repeating the same submission 3 times will not make the submission legally stronger.
I may
That's
be
not what
excused,
you're
my
saying.
lord.
We have already taken note of what you are saying. Now, what further you want to say?
Because, my lord, because of that, tribals of take a decision, my lord. I'll show, my lord, that I have not annexed, my lord. No, no. In 2003, my lord, the this is an Assamese person and the translated person also I am giving, my lord. This all Assam tribal Sangha, my lord, took a resolution, my lord, in the 2023 that who are writing, they are belong to Boro and Rafa community. They are asked to write common title, my lord. This is the translated copy and the resolution is backside, my 2023 and 2003, my lord. May I read the, my lord, tribal Sangha resolution, my lord. After this, my lord, taking a decision, they have to giving the every district, my lord, communicating this, my lord. Dear colleague, may I read, my lord.
Where is that finding that you belong to Boro Kosari? We don't want to read the whole resolution.
No, my lord, just I have said that the tribal Sangha, they are thinking that they are,
Where is that line? Which paragraph?
my lord, resolution number 2, my lord.
Resolution
One also, my
number
lord.
2. Okay.
One also, my lord, 11, to
Okay.
remove the,
Horonia Kosari Homprodayo 2. Azir Tarik যেহেতু অনুচিত জনজাতি হিচাপে স্বীকৃত নহয় সেয়েহে হৰণীয়া কছাৰী সম্প্ৰদায়ৰ লোকে জাতীয় প্ৰমাণপত্ৰ পাবলৈ হলে বড়ো বা ৰাভা মূলৰ উপাধি গ্ৰহণ কৰাৰ চিলাপথাৰ অধিৱেশনত গৃহীত প্ৰস্তাৱ বাহাল ৰখা হওক।
that in the syllabus, my lord.
Sorry, one resolution by one Sangha somewhere cannot make
They are not recognizing, my lord. They are already enjoying. Only difficulty with the their titles.
Yes, anything further you have to say?
The difficulty with the titles, my lord. The resolution number 2, my lord.
We read it.
My lord.
Now,
Then, my lord, that has been communicated to the every district, my lord. Then, my lord, she may come to my lord. The communication issued by the, my lord, the at 2009, my lord, by the all of same, my lord, on the basis of the decision, my lord. The 5 copies behind back, my lord. They are not denying, my lord. Even, my lord, if I tomorrow write, say any other, my lord, common surname of tribal community, my lord, they will accept, my lord. If I write to them, they have no dispute. They are not denying. I am not belong to.
আপোনালোকৰ সংঘ নেকি? All Assam Tribal সংঘ? আপোনালোকৰ? All Assam Tribal সংঘ?
he is the my lord
Please,
district.
we are communicating with him. Don't interfere. এইটো আপোনালোকৰ নেকি এইটো অংশ? Where is the decision of 2009?
That is a by the communicated by the.
No, where is the decision to that? Therefore, I'm directly inside adhere to the decision taken by the executive committee on 23/3/2009. Where is it?
And that decision is not with me. Because of
Okay, fine. Anything more?
and because of this.
Understand? Anything more?
My lord. And secondly, my lord, suppose my lord, they are trying to recognize themselves separately, but they will remain till my lord their constitutional status. My lord, in case of there is a medical case, my lord, 1996 probably, my lord, when the coast community was, my lord, by ordinance, my lord, has been declared to be a scheduled tribe, and so many people of belong to coast community, my lord, they are enjoying the status for the 6 months, my lord. Then one the medical admission case, my lord, this is Moiti Mohanta possibly, my lord. That case, my lord, she was selected in the my lord, that scheduled tribe quota, my lord.
How many? Yes, continue.
But that is scheduled tribe. Here's the one Moiti Mohanta. No, there is last one by one. Don't mix up.
Yes, please.
My lord. And then, my lord, that prior to that, my lord, since my lord independence, my lord, the common title by the used by the SMS community, my lord, belong to Bodo Kosari and Rava, also represented by the assembly, my lord. That is the my lord published by the assembly, my lord, where my lord this scheduled type reserve constituency has been represented by Das Deka people also, my lord. They are belong to Bodo community, but they are using the Das and Deka, my lord. This is a published by the my lord, the legislative assembly of Assam, my lord. I have flag mark, my lord. Those are the I have highlighted also, my lord. Those are the people.
What is this?
This is my lord, member of the legislative assembly, my lord.
No. Which page you want to
My
rely
lord,
on?
I have flag mark every flag mark, my lord. I have highlighted. This is the person representing that reserve constituency. But where this surname is, my lord, common surname of Assamese people, my lord.
Fine. Anything more?
My lord. Secondly, my lord, the founder president of the tribal Sangho is the Surendra, who is a member of legislative assembly, Boroma constituency, representing 4 times, my lord. Surendra, my lord, he is the founder. Ad hoc committee was constituted in the 1974 in the my lord, Didian, my lord, Kamrup district. Then he the initiated everything, my lord. His name is repeatedly, my lord, repeated 4 times, my lord. 4 times he was a member of legislative assembly from representing Sapaguri and Boroma constituency, my lord. Then since 1951, Beliram Das, when the my lord, the Jalukbari was.
Mr. Soronia, you have very limited time. Look at the people behind you waiting for their turn. We cannot go into all those histories, what you are trying to say.
No, my.
And Mr. Soronia, you know the jurisdiction of the court under 226. And keep confined to that. You may say something, we can hear you for the whole day. But if what is relevant for our purpose, you are not saying.
My lord, the issue is such that, my lord, required hearing, my lord. Issue is such that.
Okay, then we issue notice. We issue notice, so we don't retain the interim order and we'll decide about this issue. This is one way out. Second way out is, if today itself we appear before the committee, maybe the committee can take a decision. Then we'll be bound by the committee. We offered you half an hour earlier. And 5 hours is good enough for coming from Nagaon for any person. Nagaon is hardly about less than 2 hours nowadays. If you are interested, if you are not interested.
I'm interested, my lord. I'm interested. I'm not denying that.
You take your call.
I am not denying that.
You
But
take your
it's
call.
required hearing, my
You
lord.
take your call. Two
Because there
options.
is a such kind of, my lord, delicious.
We have heard you for
delicate
half.
issue, my lord.
Mr. Saranya, we have heard you for half an hour.
But
What
I have
we are,
more to submit, my lord.
we can submit in the hearing, not in the motion.
My lord.
Motion is always a prima facie case being made out.
My lord.
That's all.
Only they are
Not
doubting.
a detailed hearing, number one. And we'll pass our, we are passing our orders. If you like, you like. If you don't like, you go in appeal.
No, my liking is not, my lord.
It's up
Only
to you.
thing is that, but
So, do you want to avail the option of going to the committee?
definitely I want to avail, my lord.
Then you take it.
Definitely I want to avail, my lord.
But then why did you do it half an hour earlier?
No, my lord.
What
because-
made you think that a 226 court will decide who is a scheduled caste and
No,
who is
no,
not a
my
scheduled
this,
caste?
I represent the, my lord, tribal Sangha and the government, my lord. They are on misnomer, my lord. They are differentiating. Soronia is a different type,
What
not
is
it is
it?
different type.
Even the tribal Sangha does not have the jurisdiction.
My lord. It is not a different
It is
type.
only the parliament who can do it.
No, they are also not recognition of the Soronia as a type.
Okay, you go on arguing. We'll hear you. Go on arguing. Yes, no. Others, please, sorry, we'll hear this matter today, only this matter. Continue for the whole day. Please continue. We'll hear you.
No, my lord. Then my committee, my lord.
No, we hear you. That is gone. Thrice we have offered, you are not accepting. Please
No,
argue.
my, when court
No,
is-
we'll pass a
No,
final
my
order.
lord, what, when putting a something, am I my right to answer, my lord? Just I'm giving the answer, my lord. Not that, my lord, I am not.
Sorry. No,
not
you give your answer. We are allowing you to give your answer. We'll hear you finally decide this matter. Yes. I think respondents are ready with your argument. Yes, please start. Continue.
Lordship may come to my lord, the book, my lord. Be published by the, my lord. First, my lord, this is page number 1. Below, my lord, Beliram Das, South Sodor, my lord, Reserve Constituency. That is 1937, my lord. That time, ST was the not concept, my lord. After the constitution, my lord, the schedule type the concept. That time, it was a only, my lord, reserve for the other backward classes, not the other backward classes. My lord. Thereafter, my lord, then page number 5, my lord.
Yes, we taken notes. Some Das are the members.
My lord.
That is okay. We
Then-
understand. Now what happens? If one Das is a member of the Legislative Assembly under reserved constituency, what happens now? Make that
That means
submission.
the tribe people who are using Das, Deka or Sonia, they are also belong to scheduled tribe community, either Rabha or Boro. That's my I want to justify.
Yes, we understand. We
That-
understand one Das may also be a scheduled tribe.
My lord.
We accept that. Now go further.
Then I will not go because here
You
all
need
are
not
necessary.
go. Yeah. One example is good enough. You
My
don't have to give substantiate with 15 examples.
Suppose, my lord,
We understand submission, Mr. Soronia is a person with surname Das may also be a scheduled tribe.
my lord,
Yes,
my lord.
very well. Now go ahead.
And my lord, if today, on today, my lord, suppose tomorrow I used
So
to-
according to you, a person with surname Soronia can also be a Borokosari.
Boro person.
Very well. We accept that also. Now, what do you want to submit?
Suppose another thing is, lordship, suppose if I today, because they are insisting to write the original title.
Mr. Soronia, you are doing some disservice to your client, frankly speaking. You are trying very hard. All your argument is leading is a person with Soronia surname can also be Borokosari,
My lord,
can also be and is are two different factors.
my lord.
Court can only decide as per your submission, they also can be.
That my,
But that will not make you a Borokosari.
my lord.
Ultimately, your petition will be, argument will be half-baked.
No, my lord.
On the basis of a submission that it also can be, a judgment cannot be passed that it is. This is where we are repeatedly asking you,
This is a
and you are
general,
not liking it. So you please continue as per your own convenience.
that is my lord in general presumption.
Suppose there is a argument that a person wearing a red shirt can also be a good boy. Does it mean every person wearing a red shirt is a good boy? This is the fallacy of your argument. We are
Not
pointing out.
necessarily, my lord.
We are pointing out in a most straightforward language. So now you continue.
Now, my lord, why?
So think before you arguing, think a little ahead. Where are you heading towards? If you are heading towards a good judgment in your favor, it is well and good. You are always welcome. We are ready to give it a whole day for your argument also, no difficulty. We'll request the other counsel to bear with us. We'll accommodate them on some other day. But are you heading towards a judgment in your favor with this argument? Every material produced, I have meticulously heard you. All leads to a possibility that a person with a surname Soronia may also belong to Borokasari community.
My lord.
So a factual determination has to be made whether in a given case it is or it is not.
She is or not.
This is what we are trying to make you understand for the last half an hour, but unfortunately you are unable to understand.
No, my lord. While refuting by the government, they are treating his Soronia, he's not Boro. That's why I'm advancing this argument, my lord.
Your argument will not lead to a order in a 226 court. It needs a basic factual determination by the competent authority. So we are proposing you to send you to the competent authority. And you are not liking it.
My lord, I am
You are
not
definitely not
disliking
like, otherwise you would have accepted in the very first. All other learned counsel are accepting it. Everybody.
it. I agree.
And
with
everybody tries
lordship. I
to.
agree with lordship proposal.
And
It's
Mr.
not-
Soronia, courts are never against any litigant. Courts always try to help the litigants. Only when we realize that it is leading to a futility, we feel it is our constitutional duty to point out to you that. Because we are not concerned with Mr. Soronia, M. Soronia, the counsel. We are concerned more with the litigant before the court, whether we are giving justice to the person or not. When you see that the line in which the arguments are being advanced will not lead into anything else, we have a duty to also point it out.
My lord.
Or else I can hear you for the whole day. Ultimately dismiss your petition. It's the easiest thing for me to do. And I'll give every reason for my dismissal. Only hope for this person is if the committee makes a factual determination. And time is very short. It has to be done by today.
My lord, lordship,
What you are arguing is a broad-based argument, not for a particular candidate, but almost for an entire community.
not community. my lord.
Almost your arguments are leading to that.
Not community.
Some das here, some deca there, this there, everything you are saying.
My
What
lord,
not
there is
here?
a Mr. Soronia is not a community one. Anyway, my lord, lordship,
Whatever it is.
whatever it is.
So
lordship.
you take your call, what you want. What is best for your client, you think we'll take up after some time. Think with a more,
Let me take my lord one.
think with a more cooler mind, come back to us. Call item 2. We'll take up after 5-10 minutes.
Item 2.
Take a more reasoned and rational thinking in your mind. What should be done? And if you feel, no, this is the only argument I have and this will lead me, you come back, we'll hear you again.
More argument, but anyway, my
Will
lord, I have
not
to
only
decide.
more, we will allow you to argue more and more and more and more, and infinitely more. No difficulty with that. But think what you are arguing first.
Next item, I'm coming, my lord,
Come back, up to you.
because I have to take instruction from my client also.
Do whatever you do. Up to you. We'll hear you, don't worry. Don't give the allegation courts are not hearing. We'll hear you. If not,
Well-
it cannot be complete today. We'll continue tomorrow also. Don't worry about that.
Well,
And you are more and more, not only more and more, infinite number of mores you go on arguing. No difficulty with that also.
Item 2.
Yes, Mr.
May I please, your lordship? This case, lordships, relating to correction of age, admit card.
Sorry.
This case, lordship.
Petitioner produced relevant provisional
Yes,
law that
lordship.
governs correction of age in the past certificate.
Your lordship asked me to produce the rule 8.
So you want to correct the date of birth in the madrasa certificate?
Matriculation certificate.
Matriculation
Admit card,
certificate.
they rightly issued, and unfortunately, clerical error has been occurred lordship, in the certificate.
What is the meaning of submission rightly issued but clerical error?
Lordship,
in the admit card, they issued correctly, Lordship.
Okay, in the admit card, correct is
Issue.
there, and in the
But in
certificate,
the
wrong is there.
certificate
And
and-
who had issued this admit card and their certificate?
and Seba, Lordship.
Seva. Who appears for Seva?
And Lordship,
And
my
the
learned
TCC
friend was
there,
there. I told him, and his name not been shown,
Mr.
Lordship.
Chutia must have thought other
Yes,
matter will take long
Otherwise,
time and he went
always
away.
their name is not shown. That is why.
And-
Sorry.
In the cause list, their name is not shown. That's why
And
they have
I
used the
also
item.
told him, Lordship, he was available.
Only secondary division is shown. Item 2.
He is
Did you,
the main.
did you serve copy on the
Actually, Lordship, I find no copy served to him.
Right, then.
then
Just now,
then
Lordship.
how can you help you?
Okay, they are the main parties.
First, you serve a copy.
Lordship, on
It's stated that
Monday,
Seva is also a respondent in the writ petition, but no copy
I
had
see.
been served.
my
Petitioner
friend
may
has
serve
come.
copy on the land council of the Seva. And list again.
Copy दिया है आपने?
Yes, yes, I provide. Maybe taken up on Monday, Lordship.
Item 3, stay vacating.
We have filed an application for stay that
You are for the respondent or writ
I'm-
petitioner?
for the petition.
Petitioner. You have obtained a stay order. And Mr. Dotto seeks to have it vacated. Yes.
On the basis of the stay order, my lord, the academic charge has been given to the private respondent, to me, to the petitioner. And Inspector of Schools has taken the charge of the.
It's a regarding headmaster. In charge headmaster.
In-charge principal, my MA degree is not made because he is petitioner, my lord, he passed his MA in the year 2009. Since 2092, my lord, he has been serving as the graduate teacher. 2009, he has passed his MA. 2013, it is entered in the service book. 2018, my lord, he has been appointed as the VP. Now for
DP
the
means?
vice principal.
Huh.
Vice principal. Now for the purpose of appointing him in-charge principal, they are saying that since you have not taken NOC from the authority, so your
Oh,
MA
that same
degree-
issue, NOC.
NOC. So that is the issue, my lord. They have passed from
Yes,
idle,
who appears for the respondents?
and no NOC is required for passing an MA degree from the idle.
In fact, Mala, she also did not obtain NOC for the purpose of BA also.
So where is the requirement?
Mala,
Other rule.
And under which law?
That, my lord.
Okay, let Mr. Dotto, he wants to.
Assam Civil Service Conduct Rules, Rule 13.
Yes,
Page Mala 415, Mala.
450. Are you holding the same book?
Mala,
Same. Same.
Rule 13.
Rule 13.
Prosecution of studies by government servants in educational institutions.
Yes.
No government servant, while in government service, shall join or attend any educational institution for the purpose of preparing himself for or shall appear at an examination or recognize of a recognized board or university without obtaining previous permission from the appointing authority. Provided that the appointing authority may refuse such permission in the interest of public service on consideration that such joining or attending of any educational institution or appearing in examination may create dislocation of work or stand in the way of efficient discharge of the duties of the government servant concerned. Permission or study leave or any kind of leave granted for the purpose of joining or attending any educational institution shall be subject to the condition that the government servant shall not seek.
Mr. Dotto, we read it.
So, my lord,
Now, what is your submission?
this is the provision which has been quoted in the order, my lord, and because of that, my lord, she has been, my lord, denied the charge of in charge principal, my lord. In fact, my lord,
Where is that order? Which page?
page 17 of my IA, my lord. Is there the repetition? So it's my IA also, it's page 17, Annexure A.
Which line?
Second paragraph onwards, third paragraph onwards.
On verification without obtaining NOC. Rule 13 of the provides in view of the above MA degree.
Now, my lord,
So, Now what is your submission? We read it.
my submission, my lord, in view of that, my lord. this
Mr.
is-
Dotto, we have read it, understood it also.
Right.
We can take it that.
Now, my lord,
Now what is
she
your
has also
submission?
obtained her BA degree, my lord, which is regular course, my lord, without obtaining any permission. So therefore, my lord, this.
No, our question has some meaning. What is
My
your submission?
My submission is.
You are only telling facts till
Yes,
now.
ma'am.
What is your submission?
Since she has got this degree by not following the rules, my lord, that cannot be considered for the purpose
Please go back to the rule. Which rule?
of the rule 13, my lord.
Please take out the rule once again.
Yes, my lord. No government servant while in government
No,
service.
no. That's what I told you. We read and understood also.
My lord. So, my
Take
lord,
the words of the court to be have its in
yes, my lord.
proper meaning.
So, my lord,
Now, what rule is that?
my submission is. My
No,
lord,
what rule is that? Not the rule 13. What rule?
the Assam
rule-
civil service conduct rules.
Conduct rule. What is a conduct?
My lord,
The rule is conduct rules.
Yes, my lord.
Suppose somebody violates the conduct rules. What happens?
Normally, disciplinary proceedings to be initiated.
Not normally. It's a misconduct.
Yes.
If it is a misconduct, what happens? Proceeding under rule 9 of the
Obviously.
discipline service
Yes,
rule.
that's true.
By virtue of a misconduct being conducted,
Right.
can a degree otherwise valid given by an university
Of course, that's a valid
can
question.
be made unacceptable in law?
That is a basic question.
And that is vis-a-vis provisions of section 22 of the UGC Act. Read both the provisions together, what it appears to you.
So far the degree is concerned, my lord, that degree, my lord, I'm
No
saying will
degree
be
can be held to be invalid by any third authority unless the university itself says that the degree we have given is either invalid or we are withdrawing it.
But
A degree has to be taken note of. Number one, if somebody obtained a degree without taking permission, it is a misconduct under Rule 13 of that conduct rules.
Yes.
If it is a misconduct, only remedy available is take disciplinary action. You dismiss this person if you want. But a third agency can never declare a valid degree that I will not accept it.
well, my humble
That authority under the law is not available.
my humble submission, my lord, a person, my lord, who is apparently, my lord, not taking the permission, my lord, for the post of principal, my lord.
So we
Post
leave
of-
it open to Mr. Chisti's client that if they want to proceed against him, this man, he can proceed. You can suspend him. You can dismiss him. You can remove him. You can bring him lower in rank. Anything you want. But you cannot say, I will not accept the valid degree given by a university. What do you want to
I fully understand what you're
what you want to submit on
I
that?
fully understand. It's their responsibility, my lord, basically, to take a call on that. Since this
So
this
it
tax
is
have come to light,
now moment it is a discretion.
I fully understand.
It is never on the part of another employee to insist that you will have to take action for the
That I can
misconduct.
also, that I can also.
It is
insist on.
always the prerogative of the employer.
Yes, ma'am, definitely. That I
They
also
may
can
condone
insist
the
on.
misconduct, they may act upon the misconduct.
Yes, that is there. That I cannot, my lord,
And
claim
I
that,
don't
my
think we can pass a different order. The government may, but the court cannot. We have to take note of all the relevant provisions of law.
Actually, no, it's their responsibility, my lord, whether they don't take. That's that I
So
fully
we
understand,
retain
my
the
lord.
stay order for the time being. We'll hear you more if you want
My lord.
on this. If you want, we can give an early
Question is right,
hearing
my lord.
also.
Whether this
We can give an early hearing if you want. Come prepared on this.
well,
Mr. Das, what do you say? What is your submission?
My submission is this, my lord, if they want to go. they
What
can
we are
definitely
saying is
go,
your
yes.
submission.
And in another case, your lordship has said it's an under section 22 of the UGC.
Yeah, I
and
think we have
21 of
already,
the General
this law is already settled in one of the earlier judgments.
that I am not, my lord, disputing. my lord. My only case is, my lord, a person who is, my lord, my lord,
Tomorrow, what will happen?
my lord.
Suppose on the same principle, the court passes a judgment. Can any authority say that we are not accepting this judgment because the court did not do this or did not do that? Yesterday it happened with Guwahati University, in fact.
Right.
They were precisely trying to do that only. Can I know?
No, what your lordship is pointing is a valid question, right? That whether, my lord, without a misconduct.
Because in certain acts and relations, a third party cannot have any say. if the statute gives the authority to only one authority to determine that.
Basically, the prerogative is on them, my lord. They have to, my lord.
Or you can write to the university. If the university takes some action that yes, you fraudulently obtained a degree from us by not obtaining, they can do it.
Because it appears well, she joined in 1992, and the BA degree she obtained in 1996.
University has that discretion to say that a degree we have given, we are either withdrawing or declaring it to be null and void.
Right.
Because that also has a relevance. University may require attendance of certain classes.
Yes.
A person not taking permission means he is attending office and not attending classes.
No. She has passed.
We are not on your
No,
fact.
I'm not saying she has passed normally.
Mr.
She has
Das,
passed
we are
to
not
my
on your facts.
Yes.
Please don't spring up. We are not on your facts.
We stop springing up.
That on that principle, the university may at times that you have
Yes.
obtained a degree fraudulently from us by
Absolutely.
misrepresenting facts. We leave it open that way. Heard Mr. M. Dottal and counsel for the petitioner, also heard Mr. V.D. Das and senior counsel for the writ petitioner, assisted by Mr. B. Purokayester, Mr. S.M.T. Chisti for the secondary education department. Anybody else? Mr. Sakya, you are there?
No.
An order dated 27/7/2023 of the Director of Secondary Education Assam, dated 27/7/2023, is assailed in this writ petition. Is assailed in the writ petition 4526/2023. The writ petitioner Smriti Rekha Kolita and the applicant herein, Sikharani Devi.
No, madam, not Shikhara Devi. She's not Mosumi Sohoria.
Achha, this is somebody else.
Somebody else.
Mosumi Sohoria are both claiming their respective legal rights to be the in charge principal of Mongoldoi Town Girls Higher Secondary School. In consideration thereof, the order dated 27/7/2023 had been passed by the Director of Secondary Education Assam, taking note that the writ petitioner Smriti Rekha Kolita had obtained her MA degree without obtaining no objection certificate or any previous permission from the appointing authority. Accordingly, it was viewed that the conduct of the writ petitioner Smriti Rekha Kolita in obtaining the MA degree without obtaining the no objection certificate or previous permission was in violation of Rule 13 of the Assam Civil Services (Conduct Rules 1965), which provides that no government servant while in service shall join or attend any educational institution for the purpose of preparing himself for or shall appear at any examination of a recognized board or university without obtaining previous permission from the appointing authority. While issuing notice in the writ petition by the order dated 9/8/2023, the order impugned dated 27/7/2023 was stayed, meaning thereby the implication whereof would be that the writ petitioner Smriti Rekha Kolita would continue to be the in charge principal of the school concerned. Please, no interference in between. The applicant has instituted this interlocutory application for vacating the interim order on the ground that as the writ petitioner Smriti Rekha Kolita had obtained the MA degree in violation of the provisions of Rule 13 of the Assam Civil Services Conduct Rules 1965. Therefore, the authorities were just were justified under the law in not accepting the MA degree of the petitioner. Accordingly, it is submitted that as a prima facie case had been made out, and also considering the balance of convenience and irreparable loss of the applicant, the interim order ought to be vacated. We have heard Mr. M. Dotto, learned counsel for the applicant. Mr. Dotto takes the court through the provisions of Rule 13, which is explicit enough that a government servant cannot undertake, cannot join or attend any educational institution or appear at any examination of a recognized board or university without obtaining permission. From such point of view, it would have to be accepted that if otherwise the factual situation is so, the writ petitioner may have obtained a MA degree in violation of Rule 13 of the so-and-so. But however, we take note that Rule 13 of the thing is a rule framed under the Assam Civil Services Conduct Rules 1965, meaning thereby that a violation of any provision thereof would have to be construed to be a misconduct. In the circumstance, what has been, no, it would be a misconduct. If the conduct of the writ petitioner would have to be construed to be a misconduct under the Assam Civil Services Conduct Rules 1965, the appropriate remedy may be to initiate a proceeding against the person for having committed a misconduct under the Assam Services Discipline and Appeal Rules 1964. But a misconduct of such nature, of having obtained a degree from a university without obtaining permission, cannot lead to a conclusion that the degree obtained from the university itself is untenable in law. A degree of a university, an university offers a degree in exercise of the powers under Section 22 of the University Grants Act 1956. And taking note of Rule 21, General Clauses Act, taking note of the provisions of Rule 21 of the General Clauses Act, it is only the university who can declare the degree obtained to be untenable in law or may withdraw it. No other third party can be understood to have any jurisdiction or authority to not to accept a degree of which is the degree offered by an university in exercise of the powers under Rule Section 22 of the UGC Act. From such point of view, we are unable to accept the view formed by the Director of Secondary Education Assam in the order dated 27/7/2023 that as because the writ petitioner Smriti Rekha Kolita had obtained the MA degree without obtaining no objection certificate or previous permission from the authority, therefore the MA degree of the writ petitioner would be unacceptable as per rule. Full stop. From such point of view, the writ petitioner can be said to have made out a strong prima facie case against the order dated 27/7/2023, as the writ petitioner, if the MA degree of the writ petitioner is otherwise valid and acceptable in law, the writ petitioner may have a legal right to be the in charge principal, and from such point of view, also has the benefit of the balance of convenience as well as would suffer an irreparable loss if the interim order dated so and so is vacated. Accordingly, the I stands dismissed on being found without merit. List the writ petitioner eligible, list on so and so for hearing of the matter. You raise some more counter argument on this, we'll hear you. When do you want the hearing? Take your day. Take your general cause is 21 or 21. 21. General Causes Act 1897. Yes, Mr. Sorani. Because you are giving some
Item 1.
importance to your matter because it is very time bound, very time
My
bound.
lord, I asked them, the guardians, my lord, they have to go to Nogao, they will pick up, my lord. Then possibly not by 3, after maybe 5, my lord.
Can the committee adjust a little of the timing? The person has to go to Nogao and come back. Ask them, as a special case, ask them to sit beyond 5 o'clock also if necessary. Otherwise, how to accommodate? There is no other way out. No, fix your time. As per the convenience, you confer amongst yourself, fix your time. Where should we put a time? Again, a man will not be able to come at 5. Suppose she reaches at 5:15. Committee will say, oh, he came 15 minutes later, nothing doing now. You adjust your own timings.
My lord,
And the timing will be fixed by Mr. Sorania and Mr. Dhar with mutually conferring with each other.
my lord, may I, my learned friend Gogoi, may inform the principal, my lord, may not be allowed because until unless, my lord, classes are going on.
Director of Medical Education will inform the principal immediately, right now.
To release him from the
to allow
classes.
the petitioner. They will do everything, don't worry. I heard Mr. M. Sorania, learned counsel for the petitioner, also heard. So Mr. R. Thor, learned additional senior advocate for the Department of Tribal Affairs, Plains, Government of Assam, authorities under the. Mr. B. Gogoi for the authorities under the Health and Family Welfare Department of the Government of Assam, including the Medical Education Department. Mr. P. Saikia for the authorities under the Deputy Commissioner Baksa. Full stop. Although notice is yet to be issued and none appears for the Tamil, none, even there Tamilpur. As per our earlier order, the Vice President of the Tamilpur District Tribal Hongho, the respondent number 6, is also present, and we have heard the Vice President. As per our earlier orders, the additional Deputy Commissioner Baksa, Tamilpur,
And DC also.
your name,
Kokila Gogoi.
Kokila Gogoi is also present before the court. The writ petitioner Driblina Saronia is a intending candidate for admission to the first year MBBS course for the year 2023 and seeks for an admission under the reserved category of Scheduled Tribes Plains. The petitioner relies upon a certificate issued by the All Assam Tribal Hongho Tamilpur District Unit, wherein it is certified that Drivlina Soronia, daughter of Khorgeswar Soronia of village Bhakatpara in the Baksa district, belongs to the scheduled tribe plains community, belongs to the scheduled tribe plains, being a member of the Boro Kosari community, which is recognized as a scheduled tribe plains under the Constitution of India, Scheduled Tribe Order 1950, as amended from time to time. The state certificate is signed by the Vice President of the Tamulpur District Tribal Hongko and is also countersigned by the
SDO.
Subdivisional Officer Tamulpur. I think one more certificate was there. No? The petitioner also relies upon another certificate dated 26/3/2013 certificate. Another certificate dated 17/7/2020. No, 3/7/2023. Also issued under the signature of the Vice President of Tamulpur District Tribal Hongko and countersigned by the Subdivisional Officer Civil Tamulpur, which again contains the same information as the other certificate, that the petitioner Drivlina Soronia belongs to the scheduled tribe, belongs to the Boro Kosari community, which is recognized as a scheduled tribe plains in the state of Assam. The Medical Education Department of the Government of Assam, you had refused.
On interim, my lord, presently she is continuing.
Not interim. Why did the petitioner come to the court?
Additional Deputy Commissioner withdrawn, my lord, after issuing this.
The additional Deputy Commissioner Tamulpur,
Subdivision.
any order?
My lord. No, my lord. No, my lord.
Had they verbally?
Verbally withdrawn from me, my lord.
Verbally, okay. Had verbally withdrawn the aforesaid two certificates.
Not
issued,
the two, that 17.
verbally withdrawn the
NXRA.
certificate dated 3/7/2023 issued to the petitioner. And being aggrieved, this writ petition is instituted by the interim order of the court. Where is the provisional admission order? Which order there is provisional admission?
My lord, that interim, my lord, on that basis, a provisional order shall be allowed.
By the order dated 25/7/2023, the petitioner was permitted to upload the Annexure 3 and Annexure 5 caste certificates, which are referred herein above, comma, for the purpose of admission to the MBBS first year course. In view of such provision in the order dated 25/7/2023, the petitioner had been given a provisional admission under the scheduled tribe plains category. The last date of finally admitting a student for the first year MBBS course is fixed by the Honorable Supreme Court to be 30th of September of every year, meaning thereby that for this year, the last date of admission would be 30/9/2023. In the order dated 25/7/2023, it was further provided that in the meantime, the additional deputy commissioner shall take the decision on the caste certificate petitioner in terms of a communication dated 24/7/2023 of the additional secretary to the government of Assam in the tribal department of tribal affairs. Where is that? 24/7/2023. So why is it referred 24/7/2023? It is not annexed, I think.
No, my lord. No,
Anyway, let it remain. In other words, by the interim order dated 25/7/2023, based upon which the petitioner was given a provisional admission, there is also a requirement of the additional deputy commissioner to arrive at a definite conclusion as to whether the caste certificates issued to the petitioners are otherwise valid and acceptable in law, as well as on facts. Considering the urgency in the matter that whatever decision has to be taken would have to be before 30 September 2023, we required the, by our earlier order dated 25/9/2023, we required the Vice President of Tamulpur District Tribal Hongo, as well as the Subdivisional Officer, Civil Tamulpur, who had signed and countersigned the certificates indicated above, to remain personally present before the court. In response thereof, the Vice President of the Tamulpur District Unit Tribal Hongo, Sri Povitra Narjari, and the additional Deputy Commissioner Tamulpur, Srimati Kokila Gogoi, was present before the court. Accordingly, by our order of 25/9/2023, we required the aforesaid two officials to make a factual inquiry in the village of the petitioner Bhokatpara as to whether the petitioner and her family, who writes their surnames Horonia, do actually belong to the Boro Kosari community. Today, when the matter is taken up, today that is as it did too, when the matter is taken up, both Mr. Povitra Narjari, the Vice President of the Tamulpur Hongho, and Srimati Kokila Gogoi, the Additional Deputy Commissioner, had made a statement that in spite of all the inquiries being made in the field level, including the family of the petitioner, as well as the other families of village Bhokatpara, who are also using the surname Horonia, no material could be found that the persons like the petitioner who are also using the surname Horonia do actually belong to the Boro Kosari community. I think this is your statement.
No supporting document.
No material supporting document. Material, what's the difference in word?
Yes, sir.
Meaning is same. In fact, material is more broad-based than supporting document. In this circumstance, we are constrained that a determination on the question as to whether the writ petitioner belongs to the Boro Kosari community would have to be made within the shortest possible time, that is before Omuk, that is tomorrow, inasmuch as the decision has to be as much as a conclusion would have to be arrived as to whether the petitioner belongs to the Boro Kosari community. A person taking advantage of an interim order and getting provisionally admitted because of the time constraint cannot be converted to a final legal right to be admitted without the core question being determined. Mr. M. Soronia, learned counsel for the petitioner, has raised a lengthy argument by referring to a resolution of the All Assam Tribal Hongho dated 29/9/2003, wherein, as per resolution number 2, the decision taken in the Silapothar session of the Sangha would remain in force as regards the recognition as scheduled tribe claims to such persons who use the surname Horonia. No material has been produced as to what was the resolution in the Silapothar session of the All Assam Tribal Hongho. Reliance is also placed on a communication dated 29/6/2009 from the General Secretary of the All Assam Tribal Hongho, made to the President and Secretary of the district units of the All Assam Tribal Hongho, that there is an instruction to adhere to the decision taken in the Executive Committee meeting of the All Assam Tribal Hongho held on 23/3/2009, and to issue caste certificates to Soronia Kosari people known under the Soronia surname as to be belonging to the Boro Kosari subcaste or Rabha caste after proper identification. No more submissions. Mr. Soronia also relies upon a list of the members in the Assam Legislative Assembly and give examples of certain names, like that of Srijut Beliram Das, who was a member of the Assembly for the period 1937 to 1946, but was a representative of the Kamrup Hodor constituency, which was reserved for scheduled tribes.
Not scheduled tribe, that time scheduled tribe.
Whatever it is, they are reserved. Similar entries are also indicated in amongst the members of the Assam Legislative Assembly, that persons bearing surnames like Das, Deka, etc., are also being elected as members of the Assembly under the reserved constituency for the scheduled tribes. By relying on such material, it is the submission of Mr. M. Soronia, learned counsel for the petitioner, that the surname is not relevant, and that persons with other surnames can also belong to the scheduled tribe community. What we understand of the submission of Mr. M. Soronia, learned counsel, by referring to the list of members of the Assam Legislative Assemblies bearing surnames, bearing some other surnames, but elected to a reserved constituency, is that a person having another surname can also belong to the scheduled tribe community. But in the instant case, the requirement is to arrive at a decision as to whether the writ petitioner do belong to the Boro caste community, and not whether by bearing a different surname of Soronia, she can also be also belong to the scheduled caste community. As regards the
tribe.
communication of the Assam Tribal Hongho dated 29/6/2009, we extract the relevant provision thereof. Therefore, the said resolution, the said communication from the Secretary of all Assam Tribal Hongho for a direction to the district units to issue a caste certificate to the Horonia Kosari people who are known with the surname Horonia to be a subcaste of Boro Kosari or to the Rava community cannot be accepted under the constitution to be a determination that a person with a surname Horonia would also be included in the subcaste Boro Kosari or the community Rava. Whether a particular community belongs to the scheduled caste, the question as to whether it belongs to a scheduled caste can only be decided by the parliament under constitution consult.
Tribe, my lord, not caste.
Constitution order ke hum kot ase. তাতে আৰ্টিকেলটো দিয়া আছে under what article it is framed. এইটো blank থৈ দিয়কচোন. Yeah, under article blank of the constitution. The constitution does not provide the authority to any other authority to decide as to whether a particular community, whether or not bearing a particular surname, would belong to the scheduled tribe community, plains or hills. From such point of view, we do not find any constitutional acceptance of the communication of the General Secretary of the All Assam Tribal Hongho. The All Assam Tribal Hongho, bearing registration number 504/1976-77, can at the best accepted to be a society, to be a society for the which functions for the benefit of the scheduled tribe people. But being a society, it cannot have any constitutional authority to determine as to whether a particular community belongs to the scheduled tribe category or not. In this respect, we also take note that earlier by a notification dated 22/6/2009, not 2009.
Or 29.
No, notification. By one notification, Soronia community were included as, I think it's not this one.
4618, my lord.
No, no, not this one. There is one more notification by which the people belonging to the Horonia community were included as scheduled tribe by the government of Assam. That one. I know. It's a long order. That by notification number TAD/BC/291/214/105 dated 5/6/2018, the persons belonging to the Horonia community were included by the governor of Assam to be a scheduled tribe plains community in Assam. But when the said notification was essayed in the PIL before the court, the respondents had produced a communication dated 28/2/2003 of the Joint Secretary to the Government of Assam in the Department of Tribal Affairs Plains that the said notifications stood withdrawn and accordingly the PIL was closed. In other words, we have to understand that in order to include a community as a scheduled tribe, plains or hills under the constitutional or under the constitutional key order, under the constitutional order so and so, it is only the parliament who has the jurisdiction to do so and not any other authority. From such point of view, all such communications, resolutions of the All Assam Tribal Hongo cannot be a basis to issue a caste certificate to the petitioner that she belongs to the Boro Kosari community. But however, it is also the submission of Mr. M. Soronia, Learned Counsel for the petitioner, that certain persons using the surname Horonia do it only for the namesake, but otherwise originally belong to the Boro Kosari community. Although we have to accept that as a community, as a whole, or on the basis of surname, a person cannot be constituted to be belong to the Boro Kosari community. But if there are individual cases that persons using the surname Horonia do actually belong to the Boro Kosari community, that would require a factual determination specific to the purpose. Yes, gentlemen, why are you standing there without proper robe in the court? You are a lawyer, I think. Just come inside. I think you are a lawyer. Are we in the court as a lawyer, or you are in the court as an individual? Otherwise, as a lawyer, you cannot come this thing. As an individual, you can. So either without the band, then if you wear the band, complete robe. Not this way. Maintain some discipline. Last thought big yes. Mother disturbing elements for the seat aspect had also been determined by the judgment and order dated 1/3/2023 in PIL 30/2019. Wherein it had been held that if a particular individual claims to be belonging to any of the recognized scheduled tribe communities under the constitution order so and so, it is the committee form as per the requirement of the judgment of the Honorable Supreme Court in Kobadi Madhuri Patil versus Additional Commissioner versus Tribal Development and others reported in 1994 6 STG 2441, paragraph 13, which would be the relevant authority to make a decision on the said aspect. We are of the view that it is neither the court under Article 226 who can make that decision unless a decision of a committee is assailed in a writ petition. From such point of, we also take note of the time constraint that whatever final decision on the claim of the petitioner to be a scheduled tribe would have to be taken on or before Kali date to Didio. Accordingly, considering the urgency, we require the petitioner to appear before the special committee in Namchupura, give the whole name, today itself. And Mr. R. Dhor, Land Counsel for the Tribal
Affairs.
Tribal Affairs Department, and Mr. B. Gogoi for the Medical Education Department shall facilitate the process that the petitioner case claim of the petitioner can be given a consideration by the state committee. Mr. Soronia states that the petitioner is presently in Nagaon and therefore it will take some time for her to come to Guwahati for appearing before the committee. Accordingly, Mr. Soronia, Land Counsel petitioner, Mr. Ardhor, Land Counsel for the Tribal Affairs Department, and Mr. B. Gogoi for the Medical Education Department shall coordinate with each other and fix appropriate time in course of the day, enabling the petitioner to appear before the committee, and the committee shall, after doing the needful, pass a reasoned order. We also require the additional Deputy Commissioner Tamulpur as well as the Vice President of the All Assam Tribal Hongo Tamulpur unit to remain present before the committee so that they can also provide their views to the committee. The committee is requested to give a final report so that the report can be placed before the court tomorrow for a consideration in this petition. This the matter tomorrow.
The report by 2 p.m. tomorrow, my lord.
Yes, that will adjust, don't worry.
My lord,
Mr. We are all flexible, Mr. So that everybody's needs are taken care of. Don't worry about all this.
tomorrow, my lord, I may not be available.
Don't worry, we'll only take note of the report. If the report is there,
My lord.
we'll make the interim order absolute, and if the report is against you, we'll withdraw the interim order. A copy of the order to all the learned council. No, to all the learned council. किमान होने लगेगा? Huh? After 1 hour. Moment it is ready, I signed it. Don't worry. And we won't have much time to correct the order. If there are some inadvertent mistakes, please ignore it.
My lord, personal.
You also want?
No, my lord, personal affairs of the ADC or my lord.
No, from tomorrow we don't.
My let me.
Further personal appearance of the Vice President for the purpose of discussion stands dispensed. You only appear before the committee, tell your all the views, let them take it. And you also show whatever material you have. Bring anything you want. Yes, please. Please start.
Lordship wanted some instructions on the last occasion. Oh, sorry.
How the
No, sorry, my lord, I have given 2 copies. Pursuant to lordship's query, my lord, on the last occasion. This is the
this calculation, the only answer, Mr. Das,
yes,
this calculation of DA 23020.
23020. Yes, my lord.
DA is at present 42%.
42%.
42%.
Yes.
This is 42% of the composite figure including PSP, or it is a 42% minus the PSP.
My lord, including PSP, 54,000.
Make that calculation. If it is including, I think, then we'll have to hear you.
Yes, Lordship. My thing is, this is revised scale. Prior to revised scale, what was my drawn salary, which I have after my promotion in the month of February.
So
I
you
have
are claiming something for the previous years? Or
yes, arrear also, because calculation
no, that will be arrear.
Yes,
Arrear will have to work out differently.
Yes.
Now,
Lordship.
what is your case?
My case is PSP is added after fixation. So
Fixation
my
means,
like my
this is
basic
the,
pay.
Madam Ghosh,
Yes, Lordship.
in all my experience, this is the most difficult word I have to understand. Fixation. Till today, I have not understood what is fixation. Fixation is a word used in different contexts by different people at different times. Please, without the word fixation, you make your submission.
Yes, Lordship. So my promotion was made pursuant to an order, which is annexure 5 to this writ petition, Lordship. Page 35, which says that I am in pay band 4 with the initial basic pay of 12,000 plus
Page
grade
number
pay
35.
35, Lordship.
Exercise of powers conferred 229, where it is pleased to promote and appoint the following until fires private sector university in the pay band 4 to a 0 plus grade pay of so and so and other allowances as admissible.
So
your PSP was not added.
this is why subsequently it was added. So may I submit? So my initial pay, so basic pay will be component of 3 parts. First is the initial pay, then the grade pay and the PSP. Right? I'm clear, Lordship?
More than clear. So now
it's 12,000. So 12,000 plus 5,900 plus PSP 1,200, which comes to 19,150.
Okay.
Yes. Then,
now where is your salary bill that was given to you not on 1st of February, on the 1st of March of 2017? Let us take a look at that.
That
we will try to understand whether
Lordship.
PSP was added or PSP was not added.
They can provide the same.
You don't have.
I don't have right now, Lordship. Then, Lordship, then if I take to page number 40, Lordship, annexure 9. So 12,000 plus 5,900 plus my 1,250 is my PSP. This is my component of basic pay. So which comes to 19,150.
Another, you already said that. Huh?
Yes, so 19,150 is in between 3 and 4. 19,150. It is in between 1900.
So yes, very well. So,
So
suppose
it's-
it is in between, then what will happen?
Next higher one will be calculated. So next higher one is 19,570.
So you should be put into this one.
Yes, Lordship.
Why?
Because while calculating also, if it's higher, so
Now
lesser
let
is.
us see the provision of PSP, how PSP was provided. Is it to be added to the ROP or
Yes.
it is only to be added to your pay you are getting?
So if I take down.
No, where is PSP?
PSP
Original provision of PSP.
PSP is annexure 4, Lordship, page 33.
33. So suppose you are making that 19 something calculation, it comes to 19,100.
Yeah, 150,
19,150. So 19,150
Yes, Lordship.
will be more than 3.
Yes,
So the next higher 4 has to be taken note of.
yes, Lordship.
And your total pay should be 47320,
Yes, Lordship.
if that is so.
Yes, Lordship.
Okay.
Yes,
Now
Lordship.
what was paid to you?
Which in their submission they have given their
No,
affidavit.
on. See, this is so confusing. No one knows. So forget about submissions. Factually, what was paid?
Is lesser. They have paid 30,000. That means prior one is 17,900. They paid me 30,000.
How 30,000?
It's from their calculation in their affidavit, Lordship. Page 63.
Summary of pay fixation, so and so. This is dated. Which date?
This they have annexed as in page annexure 1, page 63.
So they have paid you 37,160.
30,000 plus 13,300 after fixation.
Again,
That
the word
means-
fixation. You said minus the word fixation.
Yes.
Fixation is a
Then
very
I am in the
vague term.
slab of 17,900.
Huh?
If
Where do you get it?
it's in page 49.
I'm
annexure
reading page
9,
63.
63. So this 30,000 where from
Just
they
a
have-
minute. Pay 30,000 to 11, grade pay so and so, PSP so.
Where
No,
from?
no. Say,
Yes, Lord.
if you are making your calculation as per page 40,
Yes,
you
Lord.
have to show what had been paid to this petitioner
Hmm.
when this first came into force. Because everything, what happened, if you give any subsequent one, there is
Yes.
increment, there is this, there is that, all kind of things. You can never make a
Yes, Lord.
inter se comparison. So whenever page 40 is required to be implemented
Yes.
for
Lordship.
that month, how
Yes,
much
Lordship.
the man was paid. Only then I can
So,
take a call
so,
whether the requirement to be paid as per page 50 had been done factually or it is not done.
let them.
It has to
provide-
be of a contemporary period of time.
Yes, Lordship.
If you give the input data of one time, what is paid of another time, we can never make that comparison.
Yes, Lordship. So let them get the salary slip of the month of,
When was page 40 implemented? From which month? Which month? Which year?
from 2017, Lordship.
Which month? The requirement of getting the pay as per page 40 occurred in which month?
July.
The pay received for which month will incorporate this requirement?
July, Lordship.
Any idea, Mr. Das?
July. Huh?
This will,
No, no. July.
with
July.
regard to his promotion from 23/1/2017, and it will be
Understand?
having effect.
Mr. Das,
No.
person is trying to rely upon a method of entitlement that is provided in page 40. So first question we asked is from which month of which year this method was implemented. And in that corresponding month, how much pay was given to this person?
This summary of pay fixation is fixation of
And
the
Mr.
petitioner's
Das,
pay.
we would like to request to not add to the confusion, but to help us to arrive at
Yes,
a
yes.
conclusion.
Yes.
Adding confusion, you can go on doing anything.
No.
It will go on and no one will understand anything.
This is
So first question first,
No.
page 40, annexure 9, from which date this table of pay was implemented? Give us that information.
Yes, Miller.
Number one. And in that month, what was the pay given to this man? Because the claim made is that upon adding the PSP, the person comes a little over 19,000 grade pay. In the column B, the person comes little over 19,000, it comes to 19,500. So therefore, the total pay payable should be the one at serial number 4. Serial number 4 total pay is 47,320. Was 47,320 given to this man on that day?
Miller, before clarifying this, if I can.
No, first you clarify this, then you go to before.
All right, Milord. Milord, when he was promoted to the stenographer grade 1, his pay was found to be less than this total pay of 43,300, first column. That is what summary of pay fixation says, Milord. Since he was having lesser pay, so that's why his pay was enhanced to this pay, 43,300 plus PSP was added, and it came to 44,550, Milord. Page 63.
Why did you adopt that method? You have to explain us.
Yes, Milord. That is what.
Why?
Page 63, if I
see,
if your lordship permit.
No.
Yes.
If upon this promotion, the person will be in pay band 12,000 to 40,000. This is the first consideration. Okay.
Pre-revised, Milord.
Again, you are adding words. You have a very bad
sorry.
habit of just creating a confusion and nothing else.
I'm sorry, Milord.
Please don't, Mr. Das.
I'm sorry.
We are requesting you enable us to understand it,
I'm sorry.
not to misunderstand it. If you want to create confusion, anybody can do it. We don't need a learned counsel to create confusion. We need the help of the learned counsel only to arrive at a conclusion. So, listen carefully. Firstly, when the man was promoted, he is in pay band 1200 to 40,000. Is it right, Mr. Gogoi? He should be. or he will be in some other pay band. First, tell us that answer.
Stenographer grade 1.
Because
This is
Madam
grade
Ghosh
1.
claims that he is covered by this
Promotion
one.
হইকিনে এটা পালে।
Either yes or no. Madam Ghosh also may be wrong. So it doesn't matter what you have done. What matters to us is what you ought to have done.
True.
Is it correct that upon being promoted, he is in pay band 12,000 to 40,000?
Yes.
Yes. So his first month, his pay will be 12,000. This is number one. Now, you add one grade pay to that. So it comes to 17,900. Okay.
Yeah.
Now you come to page number 33. Clause 2. Principal seat pay shall be admissible to officer, staff, or reserve in addition to their respective pay in the pay band and grade pay for determining. Then they even gave out the example how to do it. Basic pay is equal to pay in the pay band, that is 12,000. Okay. Yes. Grade pay, that is 5,900. Okay. Plus PSP. PSP is
Principal pays
no, how much amount?
1,250.
1,250. When you add all these figures, how much does it come to?
19.
It comes to 19,150. Okay.
Yes, ma'am.
So now when the pay comes to 19,150, if you go back to page 40, it is a little more than 19,000. So law says when it is little more than 19,000, the next entry has to be taken note of. The next entry is 19,570. So basic pay is 19,570. When the basic pay is 19,570, the man should get 47,320. You call your accountant. You call your accountant who is making all these calculations.
If I can try to explain from this page 63, same thing has been said here also.
But then how the figure ends up to be different?
Kindly have a look then 12,000 plus 4,000.
Page number
plus
63.
63, my lord. Steno grade 1 is the heading of the column.
Yes.
Sorry.
Sorry. Then
Steno grade 1 PS is the heading of the column, my lord. 23/1/2017 promoted to the post of steno
Very
grade,
well.
private secretary, and scale of pay 30,000, 1,10,000, grade pay 13,300, PSP 1250, and pre-revised that your lordship is seeing page 60, page 40. Pre-revised is here, my lord. 12,000.
So are we given to understand?
Yes.
That the revised total becomes less than the pre-revised? If we,
no,
Mr. Das, if we accept everything you are saying, after pay revision, we have to understand that pay becomes less.
What happened in this case, my lord?
Then the man will say, give me my old pay, don't give me my revised pay.
No, what happened in this case, my lord? His pay.
Nothing can happen.
No.
Nothing can happen.
What this says,
Mr. Das, we are also aware of some financial equations.
Definitely.
Everybody is aware.
Definitely.
After a pre-revision, the pay of a person will be at least ₹1 more than the earlier one. Otherwise, it can never be a pay revision. It can never be less than the earlier pay.
No, it was not less, my lord.
And it was less because if you go to page 40, it should have been 47,000. As per your calculation, it is 39,000.
That is their calculation, my lord.
This is your calculation, page 63, not
Page
theirs.
63, that is when I'm just, if you
I am fed up about this, Mr. Das.
if two
Mr.
lines
Das,
down, my lord, I can
Mr.
read,
Das,
my lord.
your complicated arguments to create a confusion, we are not accepting it. Ask the accountant to come. Ask the accountant to come with complete records. What was the calculation of the pay when this man was promoted? The first month's pay. Ask him to come with all the registers and everything.
Can it today or Milord, can it be taken
Not
up
today, any other day, if you want.
any other date, Milord, next week?
But whatever logic you may give, any kind of interpretation, no sane person will accept that after revision, a man will get a lesser amount than what he was getting earlier.
With all due respect, Milord,
We don't want any respect. We want the answer. We don't want
Milord,
respect.
my answer is that, Milord, his salary
Mr.
was not
Das,
reduced.
your respect will not allow us to arrive at a judgment.
I understand.
Give the total actual facts.
Lordship. Any
Or you submit that Madam Ghosh is wrong in relying on page 30. Either of the two.
that is correctly, Milord, but I'm
If
trying
that
to
is correct, then it should be 47.
that is what
Reading page 40 together with page 33, I think, it is 47,000. It
No,
cannot
no.
be 39,000.
No, that is not the correct calculation of the
Again,
things.
you are saying not correct. How many times you are going to repeat it?
The understanding of the petitioner that 19,100, that is the total pay that your lordship has seen at page
40.
yes, 40, 12,000, 5,900, 17,900.
So even if
plus
it is,
1250.
even if that understanding is right, that she will not be in serial 3 but 4 but serial 3, then also it is 45,000, not 39,000.
No, it's not.
Please stop this. Come with correct facts. We can't waste time like this, Mr. Das. This is going every day. We are hearing this matter. You are trying to present something which you are unable to understand till today. A clear-cut case has been made out by the petitioner. Page 40, page 33, if you read together, it comes to 19,150 basic pay. Corresponding to that, total pay is, if you take serial number 3, it is 45,000. If you take serial number 4, it is 47,000. Somehow your calculation leads to a conclusion, it is 39,000. And you are always saying it is not correct to say. And till now, today, I have not understand what is not correct to say. Only way you can come out is if you say page 40 is not applicable. That basis of the calculation is something different and not page 40. And if it is page 40, it is crystal clear that read with page 33, total basic pay is 19,150. And when it is 19,150, it has to be, if you go by serial 3, it is 45,000. If you go by serial 4, it is 47,000. Got it? And you are not correct. I am not able to understand till now why it is not correct.
Milord, it comes from 6 CPC to 7 CPC, Milord, transformation. The pay revision
Whatever
comes
it
from
is, there cannot be any law by any kind of procedure adopted, by any kind of calculation made after the pay has been revised by an employee, the total amount he'll get will come down. It can never be. Forget about 1 rupee. It may be, it can be come down to paisa also. It has to be at least 50
pay
paisa
revision,
more.
Milord, that never pay will be reduced. At least 1 rupee, it will
So,
be enhanced.
on
But
the day this man was provided, is he covered by page 40? This is the first question you have to answer.
On the
If
day,
no,
yes.
tell us why no. No. If yes, it is clear it is either 45 or 47, not 39.
Milord, I'll do one thing, Milord. I'll just place before your lordships
Get the records. We don't want
records
anything.
on the
The
date of pay
respondents
fixation
in
on the date of promotion.
High Court to produce the records of the pay paid to the petitioner immediately after being promoted as a grade 1 stenographer.
Yes, that will help me.
And also whether the applicable pay band as available in page 40 would be applicable to the petitioner. And if not, why?
I'll get.
If he is your employee, if he is entitled to more, give it to him.
Yes, my lord.
If he is not entitled,
If he is
don't
entitled,
give
my
it.
lord, he'll definitely get. There is no.
But till today, why are you making all these complicated
Perhaps,
things?
my lord, I have not been able to convey to you.
You are
lordship, sir.
absolutely not able
I
to
understand,
do
my
it.
That is my fault, my lord.
Not your fault.
Perhaps.
It's a fault of the person who is giving you the instruction.
Well, I'll produce the.
These are accounts, only the accounts people can give you proper
Yes,
information.
my lord.
And that too on the basis of actual records.
Record. I'll
Not
produce-
on the basis of interpretation, not on the basis of understanding, not on the basis of.
These are all mathematical calculations, numerical calculations.
First question first, whether page 40 is applicable. If yes, then why don't you go by page 40 calculation? Read conjointly with page 33,
Whether serial number 1 or serial number 4 of that page.
3 or 4.
Yes.
And even if it is 3, it is 45, it is 4, it is 47.
47.
It can never be 39.
They have done it in 1. Why? That is the query of
You'll
yours.
have to tell us.
Yes, I got your question.
Without the sentence, it is not correct to say.
I'm sorry.
Once you produce the record, we will examine.
Everything.
And
will
if
be
your basis we have taken is right, we will dismiss the petition.
clear. No. I'll assist this court.
Based on
Tomorrow, lordship.
tomorrow.
Sometime.
Why? So that next month salary comes in a proper way. Tomorrow is 29. So on 1st of October, you'll get the correct one.
Bill go late.
Can it be on Milord?
Don't make it too long also,
No,
because
October 5th, because second we have
October
vacation.
5th not required. Any other day?
6th, not 6th.
6 days.
Friday.
Right.
Huh?
10th October.
10th.
Fine, my lord.
And Patha, lordship, it was Patha.
If it is, it will remain.
Deep tube.
Mr. Das,
My
just
lord, I'll assist your
ask
lordship.
this accounts man to come to you,
Yes, my lord.
tell you why it is happening, and don't go by their stories.
No, I'll not go. I'll apply my own mind,
Apply mind,
compare with
see,
the basic.
And just ask them one question, whether page 40 is at all applicable.
Yes.
If not applicable, we'll have to look at from a different point of view. But if applicable, read with page 33, the only answer is it is either 45 or 47.
My lord, there is no doubt about the fact that page 40 is applicable or not. Page 40 will have to be applicable, made applicable in all the cases.
See,
only question is whether 1 or in between 3 and 4. Perhaps.
No.
Because they have initial.
No, the basic comes to 19,150. We have
And-
made the calculation before.
Yes, yes. That is
before
what
you.
I'm trying to
Once
say.
it is, basic is 19,150, either clause serial 3 is applicable, which is 19,000 exact. But what she submits is, even if it is 1 rupee more than 19,000, the next
Higher.
one, then it is serial 4. Either way, if it is 3, it is 45,000. If it is 4, it is 47,000,
Yes,
but not 39,000.
yes.
This is what we are intrigued little.
I'll clarify. I'll produce the document.
Sixth.
Sixth. Deep tube.
Otherwise, you can never explain. And the affidavit, therefore, deliberately, we are not going into it.
My lord. It is better to have the records, my lord, always. because no cheats will come, then everything will be-
Nothing will come. So you look into it. If the basic calculation is right, we'll dismiss the petition. If it is wrong, we'll ask you to correct it.
I'll-
Any urgent matter? Very, very urgent, not merely urgent.
Item number 5, my lord.
What is the urgency?
Urgency is there because the person is, my lord, without job, my lord.
Without job.
Illegal termination.
If he
Since
is without job for
2005,
so many years, he can remain for
my
another
lord, the
2 days.
director has filed, my lord, affidavit,
Madam-
whereas everything
Madam
has been
Chaudhary,
admitted.
If he can remain without job for so long, it doesn't matter for 2 more days.
Yes, my
Not that it has to be done today only. It will no urgency. This any real urgency,
Item number 20.
And,
Not the-
my lord, item 30, my lord, regarding
not the desired
non-creamy-
urgency,
non-creamy
the
layer certificate.
actual urgency.
Non-creamy layer certificate for medical.
That
admission.
one will take up
That
at
is at my lord, serial number 30.
that will take it up. He looked a site going to 31. What is item 31?
30 and 32, my lord.
No, that
also
I understand. One is
medical.
non-creamy layer and the other one is,
Same, my lord, non-creamy.
these two will take up at 4 o'clock.
30, 32.
We'll sit again at 4.
Item
Along with
number
29, man. Along with 29.
29, 30. What is 31?
31, my lord, that rape victim, my lord, minor, he gave birth to a child, my lord, at the age of.
Oh, that one can wait.
It can, my lord.
Tell Mr. KL, he may be
Item number
alert
20.
today.
Item number 26.
That one will list it next week, 31.
Item number 26, part that matter. It will come up on Tuesday.
Okay, take it.
Tuesday, Lord.
Whichever is convenient, you take it. Don't tell us about the dates. Yes, Mr.
23 and 24 next week.
For item number 11, minute, I said,
So we'll come back at 4 o'clock for item 29 and 30.
minute for
And rest, some dates, convenient dates will be given.
item number 11, I'm paying for a date. Minute.
Rejected. Don't give that for this.
What is ready, my lord? Partially. So
Which
we are
is
filing
item
an-
5.
5, my lord.
On that digging.
Yes, digging, my lord, if my lord recalls, my lord, we are conducting a study of whole Assam, my lord. So we are filing a partial report by affidavit.
When?
A report is otherwise.
No, when you file the partial report? Today?
It is there, my lord.
Actually, it's
by-
already been filed.
No, by Monday or Tuesday we can file it, my lord. It has been received. We'll file it by Tuesday. Or my lord, by tomorrow, my lord.
On the prayer of Mr. D.
D.
Gogoi,
Gogoi.
Land Council for the Forest Department. List again, next Thursday. Tentatively next Thursday, subject to change of the date.
My lord. Where is that?
3:30 করি তো only. 3:30 করি to you. Not 4.
Thursday.
Yes, Mr. Nath.
But item number 6, 7, and 8, no? Lordship, I prefer. Lordship, in respect of item number 6, 7, and 8, no? Lordship may not be taken today.
Hmm?
Lordship may not be taken today. Item number 6, 7, and 8.
We should not take.
Lordship.
No,
May not be taken.
before some other bench.
No. But I have some difficulty.
Matter should not be taken
May
up
not be
today.
taken up today.
Okay.
I have taken the content.
John on the prayer, Mr. D. Nath, I'm sending on that, okay, to be listed on.
After a week.
Okay, 10 তারিখে তো চলে second half wait হয়নি গুটি কেটে ম্যাটার গুটি কেটে
No. 10 তারিখ হোক।
10 তারিখ। 10 তারিখ।
এই টু 10 তারিখ হোক। আপনার লোক পাঠাবো।
10 10.
8 to 10.
Maybe on 10th floor.
2 o'clock. Ajin is
See, for one matter, we settle for 4 o'clock. Mr. Gogoi, we preponed it to 3:30. Now, Mr. Nath, we are preponing it to 2 o'clock if everything has to be taken on the same day.
Lordship.
6, 7, 8.
May it please your lordship, I beg to mention item number 42. Lordship, kindly adjourn the matter for today.
Which one?
42.
42, lordship.
42. What is 42? Okay, that matter. Okay. Adjourn on the prayer. So we list it again. Date you take up with the registry when they can list it.
List again.
For 10th, we have fixed specific 3 matters. It will take time. For your matter, you take up with the registry.
Item 4 for admission. Item 4.
Yes, Mr. Chaudhary, something is happening.
Lordship, on the last occasion, Lordship directed us to file an affidavit with regard to the status. Yesterday, we filed it. That is not on the record. Lordship, I have given a photostat copy.
It's okay. No. Is there some progress?
Yes, yes, your lordship.
Progress is there.
Yes, your
If
lordship.
Madam Bhuya is happy, we are also happy.
They have taken some steps, your lordship. And
Because see, this is a serious problem. It's not that it will be solved in one stroke that entire thing will be solved. You have to
step by step.
Step by step, over a period of time, if you put the pressure, it will be solved.
Lordship, that's why with regard to the testing and everything that has been going on, but what is the outcome? Only the food and safety department can say.
Food and safety, Mr. R.K. Bora.
No, Lordship, Mr. Health, under the health department, Lordship, Mr. Bora. He was supposed to be here.
Where is he gone?
Yeah.
Dinath? No, DP Bora. Ask him.
With regard to the agriculture department, Lordship, we have been, there are some difficulty because when we, whatever the food and safety department has stated that these are unsafe pesticides or vegetable, Lordship, when we try to get to the source, it appears that they are aggregated, they have collected from different sources and they are unable to identify it. That's
so the what different sources? There's
and they are going
source
into the,
from where they purchased.
Yes, Lordship. They are going into the weekly market or any other places, purchasing little bit of from here, little bit of
pesticides.
Pesticides or the
No.
vegetable. And
no, Mr. Chaudhary, that is not to be looked possibly from that way.
No,
some bit of chemical, some bit of pesticide is possibly also permissible.
Yes, Lord.
And
yes, your lord.
And up to a particular extent, it may not be harmful for the body also. Only thing when you overdo it. So that's why we said that only thing is to test the final product, that is the vegetable. If it is containing more than the permissible limit of the offending substances, that should not find way to the market.
Yes, yes, Lordship, that's why in that manner, because they are after spraying the pesticides or any other fertilizer, there are certain...
Because possibly agriculture department cannot take a stand that henceforth don't use any pesticide, any chemical, any fertilizer.
No,
possibly no. Because there are two concepts. One is organic farming, one is non-organic farming. Everybody cannot be compelled to go for organic farming because even the organic fertilizer are not available in that quantity that every farming will be now converted to organic farming. Inorganic farming has to remain. Only thing, the offending substances that are used in inorganic farming should be within the health limits as may be permissible for the health of the people.
Yes.
But some of the vendors using your lordship, the banned pesticide, your lordship, which was
Sorry?
already banned by the government of India, your lordship.
Some banned substance.
Yes, sir.
Then collectively, the agriculture department, food safety department, police department will have to act collectively. If somebody is using banned substance,
Yes, sir.
that will be a criminal offense.
Yes, your lordship.
Book him under the criminal law. Book the vendor. Book the vendor under the criminal law. The vendor will come and disclose, I purchased from so on, and investigate and go on and on.
Yes.
From where it is coming and who is making. Ultimately to the source. Ban substance. And which banned substance is being used?
And they have some, and the last occasion, they have submitted an affidavit.
No,
where
you
they-
made a statement they're using banned substance.
Yes, your lordship. In their affidavit, in somewhere they have mentioned that this is already a banned substance. And in the last occasion where they have submitted an
So no,
Yes.
is there any material to show that the banned substance was also found in some sample collected?
Yes, your lordship. But presently, I
Which collection, which vendor, which vegetable?
no.
No one knows. Then how can we proceed?
Yes, sir.
Court of law cannot proceed merely on a
Yes, sir.
odd statement being made here and there. If you show us that in this vegetable, this particular banned substance is used, it is found in so and so, then us will direct them to take action.
Yes, sir.
But our orders should not be unimplementable.
Yes,
It should not be only ornamental.
Yes, sir.
It should be
Yes, sir.
implementable and effective.
Yes, sir.
And Lordship, we have also written to the Director of Plant Protection and Quarantine Storage under the central government, where they test the biopesticides. And they have also responded. They have directed the Guwahati authority to cooperate with the department and do the necessary testing wherever necessary. Because they are some are using the biopesticides also, Lordship, which are also harmful.
Chemical pesticides.
Biopesticide means?
Lordship, page 244 and 245 in that affidavit. Today we have.
পঢ়াই ভাল নেকি পিছত লৈ যায় কিনো লিখিছে এনেই ওপৰৰ পৰা কৰি থাকি একো লাভ নহ'ব we do one thing we an affidavit had been filed by the respondent about 3% order dated 8/8/2023 the affidavit is taken on record this next week list on 10 let us read what it is.
Yes,
otherwise we can't just go on beating around the bush here and there. Let us read what specific is there and see what further to be done.
And Lordship, I seek your Lordship liberty. Anything that has been there is development subsequently.
You can
Lordship,
file
that
one
also
more. You'll file one more before 10. And if you are, we are continuing with the proceeding. You are working on it. We know if you have any difficulty,
yes, Lord.
Whether we can remove that difficulty. So you point out some difficulties, we'll look into it.
Yes.
If we can help in removing the difficulty, we'll remove it.
Yes, sir. We'll pay.
And in this kind of matters, total eradication is best. Second option is, if you can reduce also,
yes,
at least some lives will be saved. Instead of there being 100% contaminated villages, vegetables, if you can reduce the numbers also, at least some people, lives of some people can be saved.
The government has also taken some proposal, your lordship.
Who?
Food safety and department, your lordship.
But they are not here today, no? They are not
Yes.
present. Food safety department is not present today, Mr. Nath. It will list on 10. On
Yes,
10th,
yes.
we'll look into it.
Yes, sir.
Both the petitioner as well as the respondents may inform the court with further materials regarding the availability of contaminated vegetables in the market, and what further steps can be taken to reduce the same. Reduce or eradicate the same.
Item 9 for orders.
Meet please, Your Lordship. Lordship, this matter can be fixed for hearing.
Yes, start.
Your Lordship,
Are you ready, Mr. Chaudhary? You are ready?
Lordship had
Some kind of preventive detention.
Custodial debt. Your Lordship.
Custodial debt.
and
An army personnel picked up the petitioner's husband.
Lordship had asked me to take it up with the authorities if it can be resolved in that level.
One way is without determining any liability, without placing any responsibility on anyone. It's a matter of almost 25 years, I think, by now. If the petitioners are happy with the payments of some compensation, whether something can be paid and the matter be closed. This is one you are looking at it. We need not go. If the matter is contested, only way out is inquiry.
Because
So once it is inquiry, then the question will come whether evidence of 5 years prior is still available. But without going into all those aspects, if we take note that there are enough materials to indicate that these people were in the custody of the army authorities. What happened, we don't know. For that purpose, pay some compensation and that will be a compensation in the nature of no liability and no further implication. Just close the matter.
that is what Lordship, I have taken it up with the
They are
authority.
not agreeing.
It's not agreeing, Lordship, but unless there is some kind of a direction, Lordship.
So direction will issue.
That is
Direction we are ready to issue.
because without any direction, Lordship,
So if we issue a direction, it's
That
okay
is-
with you.
that
No? Take your seat then. We'll simply say enough materials are there that the persons were in their custody and enough material to show that they are no more. Something had happened. Without going into the question how it happened and who is responsible for it,
so far as Lordship,
and taking a cue from that judgment in re police reforms, where Mr. Nath was handling that matter in the other Assam government matter, where it had been provided that in case of a custodial death, without going into the question how it happened, who had done it, some compensations you were entitled. We borrowed that principle, invoke that principle, and order you to pay some compensation. Only thing, how much, Mr. Doctor? Don't ask too much, they will say no. Then we'll be compelled to determine.
There are 3 petitioners there. So
How much will you be happy with?
5 lakh each.
Yes, Mr. Because in the police reforms, as per some notified government of Assam, they are paid some 3 or 4 lakh something.
so far as Lordship, lying in custody, Lordship, that has to be.
See, here is a case, entry point is established,
Lordship,
exit point is also established. Difficulty is
in between.
what happened between the entry and the exit. So that means the death took place while or in and around while being in custody. And the judgment of the Supreme Court in police reforms is that without going into anything, merely because it had happened, doesn't matter even if that man is wholly responsible for himself. Some compensation in the public law remedy.
Worship, so far as the quantum that my is suggesting, I'll just have a confirmation with the
That one.
authority.
And tell them that suppose somebody dies in a police lockup or in a jail or this thing, the compensation paid is about 4 lakhs. And he's asking for 5 lakhs.
Let it be in the next week, Lordship. I'll have a confirmation from that.
And after 25 years, they're not asking anything more also. They're not saying that give me 30 lakhs, 40 lakhs and all kinds of things.
I do understand. That much I will do.
Or if you are trying to reduce it, we may also put it the other way. Okay, we will pay you 2 lakhs. Agree with you.
Interest.
But from the date of the occurrence.
I understand both ways, Lordship.
No, it's only date of the occurrence. And mind you, we are not trying to evaluate the value of a life also.
No, I get your Lordship. I get your Lordship. Lordship, can it be on 6th, Lordship?
And 10th we are sitting with this man. That's difficult to assemble also.
In the meantime, I'll get the
Previous list on sets.
Obliged.
Item 10 to 40. 41.
Where is Mr. B. Chaudhary? He was sitting all along. You please take note because yes, Dr. Saraf. We have heard you to the extent you have argued, and we have also understood you. So, do you want to submit more, or we can hear the other side?
On this issue, there will be more supporting judgments, but I think at present, on the same issue, for discrimination and all.
No. That's why I said, when we said we heard you and understood you, after hearing you also understood something.
Well, yeah,
How the issue can be looked at. Based on that understanding, should we hear the other side or we hear you more?
On that issue, you also may.
What we understood. But what we understood, we have not disclosed this now.
Whatever your lordship understood, ultimately,
What we have understood, we have not disclosed till now.
No. Only the other two issues are there, but I think first issue
means other two is
that Article 286 of the Constitution of India, there is a restriction that no state can levy the tax on the sale and purchase of the goods in course of interstate trade and commerce. Now, there is also a provision that when the goods are imported from outside, then also the state cannot levy the tax. Now, so far as the import is concerned, they have made a provision that no entry tax will be there.
Will it not be a little complicated and venturing into uncharted waters?
No, this is also the ground of challenge, because the import they have made provision that it will not be, entry tax will not be there. But so far as the interstate sale is there, they have not made a provision.
Dr. Saraf, tell us one thing. Yes, very. Mr. Chaudhary. No, Mr. R.K. Chaudhary, Mr. B. Chaudhary. Because we have to hear him now. I have to put him the question. Where is he gone? He was here sometime back with the agriculture department. Where is he gone now?
Code 17, madam.
Code?
These are being there, madam.
Code?
7. 17.
Code 17. But how can you keep on waiting for him now? And this is the only matter. If we close it today, okay, we'll keep Dr. Saraf engaged for some time, ask him to come fast. Actually, in fact, we want to hear him on something. So, হেৰি খন ক'ত আছে? এই যে entry tax খন যে দিছিলে যে entry tax on the entry of specific to any local area. Local area মানে আমাৰ এই ইয়াৰ পৰা ইয়াত সোমালে হ'ব, ইয়াৰ পৰা হ'ব। Meeting continue. Dr. Saraf, can we have your expert knowledge? What is VAT? Assam Value Added Tax Act. What is VAT?
This is natural sales tax, right?
Understand sales tax. How it is imposed?
Because this is on the earlier the sales tax was there.
No. How is it imposed?
On the sale.
And no, understand sale. How is it imposed? If goods coming from another state into Assam, sold in Assam, will it be subjected to VAT?
Yes. If the delivery has been taken by someone, if the goods are coming from outside directly to the consumer, then no VAT is there.
If the goods are coming directly
To the consumer, the person like I'm importing the goods from outside.
Suppose I import marble from Rajasthan and start building my house.
Then the VAT will
There is no VAT.
No VAT.
Suppose one dealer imports it from Rajasthan, then sells it to me, I purchase from, then VAT will be applicable. Will CST be applicable in this case?
CST, in case I import, the CST is applicable.
Where is what is the implication of CST and VAT?
Well, the CST is the from the state where from the goods moves,
Uh,
and it will be collected by that state from where the state originates.
no, suppose I procure marble from Rajasthan for building my house, I'll be paying CST.
Well, the person concerned who is sending it, he will charge.
No, I'll have to definitely purchase from someone in Rajasthan
So
because I myself will not go to a miner.
He will charge in the bills and the amount.
So the person who will sell that marble to me in Rajasthan, he will take the sales tax, CST.
CST from collect the CST from the person concerned, and he will deposit the CST there.
There. And I'll receive the goods here
Right.
and start building my house.
Right.
So ultimately CST I will be paying.
Yes, but then
so I will be paying through the Rajasthan person. It will be deposited. So I am paying CST for these goods.
Right.
Suppose same Rajasthan dealer, he sends the goods to another person who has a business dealing here.
Right.
Then will he pay the CST?
Yes.
He'll pay the CST. And from that dealer, I purchase the marble for my house. Again, VAT will also be paid. So it will be CST plus VAT.
He will not charge the CST thereafter from you. Well, the once the
No, but he already paid by somebody.
by somebody else paid, so he will when he will sell it, then he will charge the VAT and VAT will be paid. Like a dealer is importing the goods from outside for the purpose of resale, like marble is imported by a dealer from outside, then that dealer will have to pay the CST, and once he makes a sale to the consumer, then he will charge VAT and the VAT will be paid. The consumer will pay the VAT.
So the dealer in Rajasthan will pay CST.
Right.
The dealer in Guwahati
Will pay VAT.
While selling it to me will pay VAT. So for that marble, two taxes are imposed, one CST, one VAT.
Well, that CST will
Same slab of marble, CST will also be paid, VAT will also be paid.
that CST will become the part of the cost of the goods. You know, the CST.
No, we understand. That is only an accounting.
Burden will be.
So, a slab of marble, I purchase from a dealer in Guwahati, buy it from him and use in my construction. For that slab, Rajasthan dealer will pay CST, Guwahati dealer will pay VAT. Ultimately, I am purchasing means whole money I am paying. Dealers are only mediums through whom it is being collected. So I pay CST, I also pay VAT. But if I do away with purchasing from the Guwahati dealer, I directly contact the Rajasthan dealer.
Then only CST.
Then I'll pay only CST. Only one tax will be paid. In the first example, two taxes will be paid.
Payable means burden will be both will be there.
That's all.
And in case
I being the consumer will pay two taxes.
in case
ultimately.
that dealer has got a branch here or a consignment agent here, and he will transfer the goods to a consignment agent or the dealer, then no CST will be there.
Only VAT.
Only when they will sell.
So now, in this arrangement, this slab of marble, suppose I use it, you use that consignment dealer concept, or I directly buy from one of the shops in Guwahati. This slab of marble just where is that judgment of the Supreme Court? Article 304 to Constitution below. Ha. 304A expression is manufactured or produced in that state. So now this slab, which I will purchase from my Guwahati shop, pay VAT, and that slab is also subjected to CST also. That's marble slab, will it be a goods manufactured or produced in Assam?
No.
No. No, we have asked you this question for a particular purpose. If this slab can be construed to be, please look into it. There is a possibility also. If this slab can be construed to be a goods manufactured or produced in Assam, because of this intervening accounting and tax paying procedure, then the arguments that you were raising till now, we find some very good something in your favor. By reading section 3.1 and 3.2 conjointly, because 3.2 says, notwithstanding anything contained in subsection 1, production revenue, no entry tax shall be levied on such specified which are also taxable under the VAT. So if this slab of marble can be construed to have been manufactured or produced in the state, and it is subject to VAT, then it will come under the exception of 3.2, meaning thereby, by instead of imposing the tax directly, it is sought to be indirectly done by through the means of a VAT. That if VAT to exempt the goods manufactured or produced in the state, but at the same time tax goods which are being brought from other states, then this bar under 304A will be squarely applicable. But that's why we're trying to get from you, by giving this example of a marble, by subjecting it to VAT, can it, by under any relevant consideration, be construed to be a goods manufactured or produced in Assam?
No.
If yes, that would have been a very easy answer for you.
But Milo, the schedule contains many items.
Sorry.
The schedule of the taxable goods and the Anti-Tax Act contains many items which are also manufactured and produced in Assam. I give example of cement. Cement is produced and manufactured in Assam also.
But it is subjected to entry tax.
Well, that's why I'm saying that the same thing, entry tax is subject to, VAT is also there. So the item, assuming I import an item of cement from outside. Now the cement, when I import from outside a consumer, he has to pay the CST as well as the entry tax. Now a person who is manufacturing in Assam, Melo, then he has to pay only VAT.
No, also entry tax.
Entry tax will not be payable once the goods move from one local area to another local area.
And then he'll pay.
And the VAT will not be payable. VAT is paid. The entry tax is not payable.
Understand. So by 2, this particular goods, entry tax will not be payable even if you're moving from one.
My lord.
No, if that's, again, I go by that marble example. If that bag of cement is purchased by the person who is consuming it, then he'll pay only CST.
Only VAT.
Only CST, no, outside.
From outside, then
only CST.
CST and entry tax.
Entry tax for the time being, you leave it out.
My lord.
Otherwise, you'll make an. So he'll pay only CST. Same bag of cement.
Purchase in
if I
Assam,
purchase from a shop next to me,
VAT only.
I'll pay CST plus VAT.
CST burden, if your lordship says, yes.
A burden is a tax. Ultimately, tax is money. Other than all the technicalities here and there, tax is money. Means how much money I am paying to the government for procuring this good or
What is the
this
actual
service.
cost?
Huh. This is what the actual consumer is paying. So I am paying tax. I know actual cost, although accounting procedure may show it to be cost.
The total burden of the
But
tax.
I know that this much of money I am paying to the government in the form of CST, and this much of money I am paying to the government in the form of VAT. But it is I am only paying, the person who is consuming it. So this bag of cement is also subjected to VAT. So once it is subjected to VAT, the entry tax is not payable. But if I don't purchase it through a shop, I purchase it directly, I need to pay entry tax. I'll have to pay because that VAT element will go out.
What is the question?
It's a complicated equation.
Well, the question is that there are 3-4 situations. In one case, I purchase the cement from outside for my own consumption. I need to pay CST and entry tax.
Entry tax.
I purchase the cement from a dealer in Assam, manufactured in Assam. A manufacturer in Assam.
You pay only VAT.
I pay only VAT. I purchase a cement from a dealer who has imported it from outside.
But purchase from another dealer here.
Purchase from dealer who has purchased it from outside. Then the burden of CST and the VAT will be there. I purchase from a dealer who is having a branch office, like the company is there, he is having a branch office. I purchase from him. Then I will pay only VAT, CST will not be there.
No entry tax.
Entry tax will not be there because once
the VAT is there.
VAT is there, the entry tax is not there. So the question is that, my lord, a person who is purchasing the goods from directly from outside, the burden of tax, and I will also kindly remember, my lord, when a consumer purchases the goods from outside, he has to pay 10% tax. But a person who is bringing the goods for resale, the rate of tax is 2%, CST.
Okay, CST again goes down.
Goes down because he has to give the C form, and on that he has to pay 2% only. So if I purchase, even if I purchase from outside a dealer in Assam, the burden of tax will be much less because VAT plus 2% only. But if I purchase from outside, then I have to pay 10% plus the entry tax.
The C form business will not be there.
My lord. Because the C form can be issued only when somebody brings the goods outside for the purpose of resale or use in manufacture processing goods.
So now how 304 will be violated in all these examples?
304, if you also
because just what I was thinking, if there is any provision to construe that on being subjected to VAT, it can be accepted that it is manufactured and manufactured and produced in the state, then it would have been very easy for you.
If your lordship takes that view, then your lordship has to decide on the basis of the item which are manufactured and produced in Assam and the item which are not manufactured and produced in Assam. The item which are manufactured and produced in Assam, then that will be violative of Article 304A. If you know the view that the item must be produced and manufactured in Assam, similar goods. So the items which are in the schedule, which are
No, we are not thinking in the terms you are thinking. We are thinking in a little broader perspective. Any goods coming from the outside into Assam subjected to entry tax. Same goods subjected to VAT, no entry tax. So if that goods under any provision can be construed to be a good manufactured or produced in the state, a good which is subjected to VAT, is to be considered to be a goods manufactured or produced in the state, then the entire provision of 1 and 2 read together will render the entry tax violative of 304A.
Hello, your lordship is same, 304A, your lordship, once again.
No, you read it.
Hello, I may just read for my benefit. Notwithstanding contained in 301 or Article 304, the legislature of the state may, by law, impose on goods imported from other states or from the Union Territories any tax to which the similar goods manufactured or produced in that state are subject to. Similar goods manufactured and produced in the state are subject to. If I purchase the goods from cement from outside and the cement which is manufactured in Assam, similar tax they are not subject to, then it will be violative of Article 304A of the Constitution of India. In my humble submission, my lord, it is not necessary that the goods which are imported must be deemed to be produced and manufactured in the state. That is not the 304A. 304A says, my lord, the tax which is imposed on the imported goods, the similar tax burden must be on the goods which are similar goods manufactured and produced in the state. So when the cement is being imported in Assam, the tax burden on the said cement must not be higher than the cement which is manufactured and produced in the state.
The entire difficulty, since the very first day we are, I think you are also explaining, we are also repeatedly asking. In drawing a parallel between goods imported from other states and entry of goods into local area. This is the, had the expression instead of local area into the state been used in section 3, straight away we would have lifted the provision of 304A. And
it could not have been, because NT 52 says power is only in the local area.
Understand.
So
maybe, but difficulty is the expression local area is used, and in Assam there are multiple local areas.
I'll just give an example. the goods which are entering the state is entering into a particular local area only. And the same goods are manufactured in that local area. The same goods are manufactured in that local area only. And the goods which are manufactured in that local area.
No, that's why Dr. Saraf. Had either the language of 304A been instead of other state local area, or the language of 31 been state instead of local area, then retaining the parity, which would have been the easiest of the decision, that whatever you impose on goods brought from other states, same you will also have to impose which are manufactured or produced in the state. Then answer would have been straight away.
So that is the simple discrimination.
But difficulty is one statute is using the expression local area, other constitutional provision based upon which it is being assailed is using the expression other states. And had local area and other state being same in the state of Assam, had it been only one local area, that entire state is a local area, then also 304 would have straight away covered. The whole difficulty that we are facing is in Assam, suppose there are 6 local areas. So in the 6 local areas, there are some goods manufactured or produced. If the good is enters from one local area to another, still it will be subject to entry tax, meaning thereby that the similar goods manufactured and produced in the state is also subjected to the entry tax, along with goods imported from other states. This
subject to I will try my best.
Understood. This is the biggest hurdle that we are getting at.
When the goods,
So to overcome the hurdle, one thought came in the mind. Somehow, under any provision of law, if it can be produced, that a good subjected to VAT is a goods manufactured or produced in the state, then the Assam would, the problem would have been very easy. But you, that's why I said we want your expert knowledge.
How I can simulate that?
But it is not. I know Dr. Saraf is most fair person. So therefore we are taking your help.
Just example, was given example, from one local area to another local area, anti-tax will be there. Now, after entering into that local area, the goods is sold in that local area. Anti-tax is not there.
Anti-tax will go away by virtue of that second proviso, second subsection 2.
That is my argument for that when the goods manufactured in the state move from one local area to another local area,
and also pays VAT.
And the VAT is paid, the anti-tax is not there. But when the goods are imported from outside.
No, this is that's why in the very beginning I started with that marble example. But that marble, which is be imported from another state, first comes to a dealer in Guwahati and then goes to the consumer. There again the VAT is there.
I am speaking of the consumer. I am not speaking of the dealer at all.
But the consumer is paying the VAT.
Consumer is not paying the VAT. The consumer is paying CST and anti-tax.
One that directly comes.
When this comes directly.
One that directly comes. But the one that goes from the shop in Guwahati.
My case is not at all on the behalf of dealers. My entire case is on behalf of the persons who are using the goods either in manufacture or for consumption, not for sale. Not for sale. For sale, there is no problem because there is a provision. My argument is there on behalf of the consumers and the factories who are bringing the goods for manufacture and producing or for consumption. That is the only case, not for resale.
Understand. So for them, anti-tax is there.
Anti-tax is there and the CST at the rate of 10% for the consumer. For the consumer, the anti-tax is about 10%. So the burden of the tax on a person who is importing from outside for consumption is much higher than similar goods manufactured and sold in Assam, produced and sold in Assam. And that is directly hit by
No.
apathy.
This is what we are trying to say. The manufacturer in Assam will not be subjected to CST because it is manufactured here. But if he sells it another local area, he will be subjected to entry tax. So he will have only entry tax and he will have no CST. But the person who is importing from another state, he will pay CST at 10% plus entry tax. So burden is more. Now, to interfere with that tax on the basis of 304A, the basis we are taking note of is the total burden of the tax. But there is no proposition of law that 304A is related to any burden.
No, that is 9th Bank judgment.
Where is it? Which paragraph?
Justice Chandrachud,
Let us see.
he said about the burden of tax.
Let us see. Which paragraph? এইখন দিয়া है হেৰিখন বতাখন মানে আছে which paragraph should I look?
Well, I just paragraph 228.
Para 228.
228. Para 728.
Oh, 720. Are you relying on this proposition? That you're holding a book, no? Is it 475 page number?
470,
75.
75 million.
Same page, no? Page is the
475,
same.
para 728.
728. Last sentence, the state legislation.
My lord.
The state legislation may have excluded from entry tax those local goods which are liable to pay sales tax under the State Act. This is same as our Act,
My lord, thereafter.
because Section 2 had
My lord.
done it. However, an importer of the scheduled goods who incurs liability under the value-added tax legislation by virtue of the sale of imported goods or the sale of goods manufactured by consuming such imported scheduled goods is entitled to a set-off. Relying only on this part.
My lord. Thereafter, Lordship, may see further, my lord.
No, further I read, but I could not find anything.
No, I will take your Lordship, my lord, the further where it is necessary. My lord, Lordship, see 732.
732.
To the bottom, my lord. The fundamental reason for the incorporation of the provision is to prohibit discrimination.
Just a little slow. The fundamental placitum.
My lord, placitum, my lord, G.
G.
732.
733.
2, my lord.
732.
At page 476.
478.
476.
That
at the bottom, my lord.
732 I am reading.
My lord, the second aspect of the Article 304A is the
It's 732 or 730.2?
730.2.
The fundamental reason for incorporation of this provision
by embarking upon protectionist policies, the discrimination which the constitutional provision is intended to rule out is discrimination which is protectionist in nature. A state cannot impose taxes in a manner that would make the goods of another state non-competitive so as to effectively bar the inflow of trade by utilizing physical expectations. Lordship, after further similar. Thirdly, the later part of 304A is prefaced by the expression so, however. In words and phrases, the expression however has been, my lord.
Excluded from entry tax those local goods which are liable to pay. If we was local good too, is again now.
The last 4 lines of 730.3. Last 3 lines of 730.3.
Even imported goods, it comes to a dealer, that is also exempted. And he had it here.
And I will also take your lordship to 732. With the last 3 lines, my lord, it says, my lord, that the latter part constitutes a positive reaffirmation that in any case, at all events, and at any rate, there shall be no discrimination between goods manufactured.
Which one? 730.2.
Point 3, my lord.
Point 3.
Last 3 lines, my lord. It's 730.4.
You must have read the whole judgment. Is this minority judgment in paragraph 728 onwards, did the majority judgment hold anything contrary to this one?
My lord, the majority judgment on this
No,
issue.
there are two situations are possible. A minority judgment may express a view which is directly in conflict or contrary to what the majority judgment had produced. Sometimes a minority view in the minority judgment may be a view independent, a question or issue where the majority judgment never went into. This is of which nature? First nature or second nature?
The
Second
major-
or first?
The
This
majority,
one?
this is third view. The majority view took note of the views.
No, we have not understood. my
I have
question.
understood. Let me
The majority suppose,
either it is contrary to the majority view,
or it is in addition,
or it is
in something in addition.
something which was not dealt with by the division.
That is something in addition.
I will say that
If anything is in addition, the minority view holds good. If it is,
contrary, this is not contrary to.
this is not correct. This is something in addition.
I will say why this. The majority view said that this is the regions, but since all these things are there, this is to be examined by the regular bench, the division bench.
But the minority goes a little.
The minority has explained. The minority has explained the matter. Now the division bench, when it was hearing, they said the necessary facts are not there, so the High Court will examine it. Now, under such situation, as you are also aware,
So we are bound by the minority.
well, according to me, my lord, because this is not contrary to the view, something which has been expressed by the majority view. Neither it is giving a judgment on the issues which are not arising before the majority view.
Understood.
They are explaining the law only. I will also just see, my lord.
Can you ready over 476? It's a Chaudhary. I think this part we find it a little distinct.
732 also, if you also. 732.
We're going to
My lord, my
that
lord.
last part of 728.
Yes, my lord.
The state legislation may have excluded entry of those, but again, Dr. Saraf, those local goods. Here, your example is every good may not be a local good, because a good comes, say that again, back to that marble slab example. Marble slab comes from Rajasthan. It's not a local good. It enters into some shop here. Then I, being the consumer, purchase the local good. I pay VAT. This marble slab will be exempted from entry tax by virtue of subsection 2. So, but this good is not a local good. It is an imported good. Only thing, it is an imported good, but because of the nature of the transaction, it is subject to a VAT. Once it is subject to VAT, entry tax is out.
The section doesn't say local goods. It says similar goods manufactured or produced.
No, I'm on 728.
Well, 728, you also see.
Expression used is local goods. The last line.
Last line. The state legislature may have excluded from entry tax.
Those local goods.
Now, those local goods have been defined. You also see in the first part.
Where is the local goods defined? So had it not been the word local, tax those goods minus the word local.
Well, I will place local also.
Then, however, an importer of the scheduled goods who incurs liability under the value-added tax by virtue of the sale of the imported or sale of the manufacturer by consuming such goods, such imported scheduled good is entitled to a set-off. So here, this we can understand as a set-off to the entry tax.
You'll also see 476.
Page
476, top.
Oh,
However, an importer of the scheduled goods who incurs the liability under value tax legislation by virtue of the sale of the imported goods or the sale of the goods manufactured by consuming such imported scheduled goods is entitled to a set-off. The state legislature in certain cases exempts goods from any tax if after entry into local area the goods are sold there.
So this will mean an importer of a scheduled goods suppose that we slab is imported. Who incurs liability under the value added tax legislation? So once it goes to a shop, value added tax is payable. So incurs value added by virtue of the sale of the imported goods or the sale of the goods manufactured by consuming such imported scheduled goods is entitled to a set off. Therefore, taking a note of this provision of the Supreme Court,
My lord.
subsection 2 is justified. So subsection 2 says that even if you are otherwise if you are an importer of the goods, you are liable to pay entry tax by virtue of subsection 1 if it enters the local. But if you are an importer of the good, but you are also subjected to the VAT by nature of the transaction, through the meaning the dealing is through the shop, then you are entitled to a set off. Therefore, they have provided subsection 2 to bring in that set off.
Kindly see, my lord. I read one paragraph. Let me read the entire paragraph. 730.4. I will read, my lord. 730.4. If you also permit me. Fourthly, an expression of some significance that is used in the
later part
of Article 304A is between. The expression has been employed so as to mandate that there shall be no discrimination between goods imported into the taxing state from another state and the goods that are manufactured and
Where is the word between?
Between, you also see between the goods.
No, 304A.
304A.
Manufacture produce this one also imported. No, where is the word between? Notwithstanding any they impose goods on state or union, any tax similar to goods are manufactured in that.
Not to discriminate between goods.
Okay, this word between. The word between, that expression has been employed so as to mandate that there shall be no discrimination between goods imported into the taxing state from other states and the goods manufactured and produced within. This is what we are trying to, at one point of time we pointed out, had section 3 used the expression states instead of local area, problem would have been very easy.
You'll also find the judgment. In the judgment, the 9th bench is dealing with the anti-tax. Anti-tax is only in the entry of the goods in the local area. Now it says
no, it's dealing with which entry tax of which state?
Assam. This is different states with the Assam was also there.
Understand? Is there a difference in the statute of Assam and the other states?
Maximum the anti-tax statutes are the similar.
Still, Assam account
if you also permit me, just
had the court quoted any of the entry tax provisions?
It must be there.
See, if you can take out the distinction between a local area and a state, you are true. We have no difficulty in understanding.
Well, if you also permit me, 730.4, I may read one concept. At page 477.
No, before, can we go through any of the Entry Tax Act that the Supreme Court was dealing with? I just want to verify whether the word local area also
the local area
was also there.
Always everywhere it is.
Or it was the word state was used. The beginning of the judgment.
When if it would have been a state, then it would have been
Then,
Step down.
then you are.
Then it will have been stepped down beyond the
So-
competence of the state legislature.
Understand.
You don't know about it.
Jindal still versus Haryana.
My lord.
So once it is Jindal versus Haryana, what is the entry tax act of Haryana? Please try to find out. Pawnee, Haryana entry tax act one. I don't think the Supreme Court had quoted it.
Because it's a constitution and Jindal.
It's that Haryana Act is not quoted. I think Paisa. Just forget of pin of deviation. Every all these things are applicable. Yeah, they have made it local area, not state. And
You know, if that is in the case there is not a local area.
Straight away adopted that 304A violent policy. So, Saraf, we'll continue on that next week. I think I had to again sit.
No, I will make a submission for Lordship.
I think you have to second sit single with some medical
If your
admission.
Lordship can one day, by from the esteemed lord, if the day can be given, then we can all finish. Otherwise, the partly it will be always.
10th whole day kori thoi diok. Paribo nei without single bench. 10th এটা defer কৰি দিলে বেটছ নাই বুলি গোটেই দিনটো কাৰণ হয়ও কাৰণ সদায় এইটো হৈ আছে in the deliberation we go and reach some point then again we have to next day we don't know from where you
I will
start.
also take a liberty from the Lordship.
One only at least 11 o'clock.
2 days if the Lordship, the other side can reply, it can be finished.
For the whole day. Hey, Haryana kan pale nahi.
And I also take a liberty from the Lordship. That I prepare a written submission and give advance copy to the other side.
I have, we told you very openly where we are having the difficulty. We are unable to reconcile between the expression local area
That I will
in
produce
this
before
act,
Lordship, that in all
and
the
the
acts,
word state in Article 304.
well, I will produce before Lordship that in all the enactments it is local area.
Haryana entity into local areas.
It's
The name
all-
of the act itself is local area.
Local area, it's all local area. Because otherwise, the tax could not have been imposed at all.
Dr. Saraf, had this been arbitration and not a rate proceeding, the charges of the arbitrator for reading the Supreme Court judgment would have been an astronomical figure.
Similar the position from this side also. Nobody is going to pay for the professional fees for reading the
Because I
judgment.
think I've taken the Haryana Act with me and to read this judgment.
Well, I will give all other acts also and say, that without the local area, there cannot be any entry tax at all.
No, then how did the Supreme Court relate between the expression state in 304 and local area in the entry tax?
Why is saying that goods which are coming from outside the state?
No, I'm giving one most simplest of the example. The good is manufactured in this state, but in another local area, imported to the other local area, will be subject to an entry tax. And 304 says only thing is if it is imported from one state and the goods manufactured in the same state is not subject to the same tax, there will be a constitutional bar. So now here is a case where goods also manufactured in the same state are also subjected to entry
Your
tax
Lordship has seen the paragraph.
by virtue of
Yes, Lordship
the
has seen the
expression
paragraph
local
just
area.
understood.
Sorry.
That these are the means by which the protective way has been
So
granted.
ultimately, I don't know when I can read the whole judgment. You have to
No,
read
I
the whole
think-
judgment in one go.
So I think
And
one
reading
judgment,
1,000 pages in one go is
reading
also,
the
I don't
judgment, my
know
lord, want.
to what extent it will be possible.
I think if the Lordship reads the Chandrachud judgment, my lord, from on the discrimination,
It's from which paragraph?
my lord, it starts from, I can give the relevant paragraphs if your Lordship want, my lord. Page numbers. I've noted, so I give them page numbers. Justice Chandrachud judgment page number.
Itu এদিন Sunday ঘৰত পঠাই দিবচোন।
I try to see whether the
I
written
think
submissions are,
one of my Sundays I'll have to use for this one. Reading your entire judgment. No
that
other
the
way
written
out.
submissions are filed.
Otherwise, this will keep on happening.
My lord, that's why it breaks, my lord, the flow. So the next day,
কোনদিনা দিব 10 তাৰিখে দিব নেকি 10 তাৰিখে মেজৰ বৃহস্পতি হ'ল দে
I try to see whether before 1 week I submit the written submissions on all the issues, so that my lord, at least other side can also be prepared and also be prepared. I will try my best, my lord.
We are yet to hear you, Mr. Chaudhary.
Lordship, as soon as the report comes
No,
from
no.
Yes, yes, by tomorrow.
By tomorrow, definitely, whatever you
Yes,
do.
yes, yes.
Without asking for the being referred to deputy commissioner, you can send your own person, get it verified and come back. Because difficulty is at 30 September. Otherwise, we don't ask you to do all this. Normally, if the committee, we give you whatever is the required time. But medical admission are different categories.
Right now also I have spoken with the
person actually belongs.
Yes.
We should not deprive. Person actually does not belong. We cannot allow man to that because that will deprive
the other person.
One genuine person down the line somewhere. Both are equally bad. So only option decided within the time. Again tomorrow.
By tomorrow,
List tomorrow for the update of the report of the committee. We have taken note of the communication dated 29/9/2023 of the Joint Secretary Government of Assam in the Department of Social Justice and Empowerment, that which provides that the documents provided by who is Deepika Bora?
Respondent number 8 here.
By the respondent. So he is challenging respondent number 8. If respondent number 8 is out, you are in. If respondent number is in, you are out. Of the respondent number 8, Deepika Bora. The deputy commissioner is also directed to act immediately on the said communication and provide whatever information material is required by the what committee? Again, a special committee ne ki kore? Naam to ki kore? Special committee. So Mr. Dhor knows the name.
State level scrutiny.
State level scrutiny committee. Okay. List tomorrow. Next one.
Item 30.
Communication of 29 kept on record.
Tomorrow at 4 o'clock.
Yes, definitely. We'll accommodate you to the maximum, but we expect something to be there.
Definitely.
And these are issues we cannot decide. Committee is the only authority who can decide it.
And tomorrow it has to be decided because that
30th
day
is
after
the last
tomorrow is the last day.
Yes, Lordship.
And once
That all-
interim order is also there.
That I have been already been informed by the Joint Secretary, but by tomorrow. he will-
In which case? Interim order.
Probably in this case, interim order is there.
Item 29. 29, there cannot be interim order. He is challenging somebody who is appointed.
And for other matters.
Item 30.
Non-creamy layer.
Yes, my lord. Here, my lord, your lordship may kindly have a look at it. This is regarding the power of the, my lord, National Commission for.
But how can it be decided by tomorrow? Because your case, other cases, it's only in one level. We direct the committee, make a determination, tell us, we'll pass our order. But in your case, in the first step, the ceiling has to be raised.
That is also there.
In the second stage, if the ceiling is raised, we'll ask the deputy commissioner to reconsider. But that will not happen in one day.
And Moreover, the petitioner does not fall under the creamy layer, my lord. My lord, there is an order of this honorable court in Rimli Saikia's case, my lord, similarly situated.
number?
My lord. Your lordship, this is the order, my lord. The source of income in case of the petitioner is only her salary, my lord.
How does it help you?
My lord, here also, my lord, the petitioner's source of income is only, she is class 3, my lord. She belongs to class 3 category, and her source of income is only her salary, my lord. And page 30, my lord, page 30, there is a question, what is the scope of the explanation? Income from salaries or agricultural land shall not be clubbed. Even
Who
below
appears for the deputy commissioner? Yes, what is the
Yes,
law?
my lord.
What is the law? Do you mean to say to determine who is a creamy layer, who is not a creamy layer, income from salary will be excluded? So that means any person who is a salaried person will always and perennially be a non-creamy layer.
No, madam, we are not doing that.
This is
Yes,
what
it is explained at page 31 very clearly at page para 10, page 31, my lord.
Whose page 31?
Page
This present
31 of
petition.
my petition, my lord.
This
In
is the
regard to
notification,
clause
my
10 of para 4,
So this law
it
we
is
are
clarified that
not very clear because these are all actually it cannot be the source of law because these are clarifications by
yes, regarding creamy layer, my lord, your lordship may kindly
Who
see
appears
income
for-
from the salaries
can
and
you have-
income from the
can you
agriculture.
have just slow. Can you have Mr. RKD Chaudhary?
RKD, my lord.
অলপ আগতে আছিল পাৰিব নেকি মাতিব চাওকচোন অলপ লাগিব তেওঁ I think he is the only person who can obtain this information.
My lord.
Whether income from salary should be included to determine the creamy layer.
Yes, my lord.
That means the salary that we get will not be in creamy layer
My lord.
because the income from salary is excluded. But at the same time, for you, had I been a lawyer, even if I get half of what we are getting now, I'll be a creamy layer. Is it not something little absurd? The entire concept, I mean. Suppose with my salary, my children will not be creamy layer because my income is only from salary. But for Mr. Saikia's children, although income of Mr. Saikia may be less than me, he'll be a creamy layer because your income is from as a lawyer, not as a salary. We are having a little difficulty in understanding this concept. Do you have any idea? You will also argue the same thing, I know.
Same thing, my lord. It has been explained in the affidavit, my lord, by the Union of India, my lord.
Whose affidavit?
My lord, if in item number.
No,
It has been explained.
no, we are bound to ask them the reason because the reason is leading to absurdity.
It is provided.
Suppose now salary doesn't mean government salary. A person works in a multinational. His salary is 1 crore per month. There are people like that. 1 crore per month. He will be per year 12 crores. His children will be non-creamy because the father is getting only salary. Another person who barely survives with a pan shop, but with a little selling a little more pan, he crosses the limit of 8 lakhs. He is a creamy layer.
The entire position has been
So the 1 crore man is a non-creamy and the pawn shop with a little higher income, he will be creamy.
it has been explained in that paragraph.
Pashanti, really. Did you get Mr. RKD Chaudhary? I think we'll have to take up this matter tomorrow. He'll have to obtain some actual information, not based on this one.
Just one
Affidavits are written by odd officers here and there. Without any basis, without any, just see, read something, oh, I understand this is there. This is
one page, if I
Madam Devi, we want Mr. RKD Chaudhary. He had left.
Lordship, just 5 minutes like left, Lordship.
Can he come back? It's a serious issue.
I'll
Just send a request, a small request. Just for.
5 minutes, I'll ask.
Otherwise, we have no solution in this matter. It is only Mr. Chaudhary who can provide some solution.
if I may just draw your lordship's kind attention to just one page.
In whose petition?
In item number 32.
32 we are yet to go.
Fine.
What is that? You read it?
Just one page shows everything. It clarifies everything. Perhaps all the doubts, the answer to all the doubts.
Mr. Counsel, the difficulty is laws, origin of law is not on clarification. Origin of law is what the original provider of the law had provided for. And most of the clarifications are always circumstantial. Somebody puts a problem, another person gives a clarification. It's not a overall consideration of something.
Once my item is called, I'll just place that page, my lord.
Yes, please. Tell you it's inconvenient for him, we know, but it is little vital and we have no time for all this.
5 minutes.
Means we don't have time at hand.
Because the category of the post has been explained, my lord. Which category will fall in criminal?
What is the scope of the explanation? Income from salaries or agriculture shall not be clubbed.
My lord, the reply is in the next page, page 31, para 10. My lord. At that particular time, it was 2.5 lakhs, now 8 lakhs, my lord. Only this difference.
Who had signed this one? Deputy Secretary K.G. Verma. Why did he sign this?
This is
Just a
task
minute.
27.
Just a minute. He is again with reference to what is the scope of the explanation. Income from salaries or shall not be clubbed. Meaning thereby it will not be added.
Only one.
But the answer is none of them will be included. Today, I put a question. You have 5 rupees in your left pocket, you have 5 rupees in your right pocket. Should I take your total money you are having is 10 rupees? Or the 5 rupees, 5 rupees other should be separately considered? You will give a reply, none of the pockets are to be considered. Is that an answer? I think this is what is the clarification. Look at the question, page 30. What is the scope of the explanation? Income from salaries or agriculture shall not be clubbed. Clubbed, we all understand, bringing it together. What is the answer given? It is clarified while applying the income tax determination of any candidate. Income from salaries and income from agriculture shall not be taken into account. So this is the example, my example. 5 rupees in one pocket, 5 rupees in the other pocket. I ask a question whether I should understand it to be 10 rupees with Mr. Saikia. Mr. Saikia gives a reply.
No,
None of the pockets are to be taken into account.
because 5 rupees in right plus in left.
At para 10, it is explained, my lord.
What is it?
At
It
the
means
bottom,
that
my lord,
if
it
the
means
income
that
of
if
is more than 12 per annum, income from say is more than 12, from other source is less than 12, that shall not be treated to be falling in it. So, my other example, a son of a high official in a multinational earning 1 crore, then a son of a rich farmer of those Punjab and Haryana types who deals in hundreds of crores. These two category of people, if their income from other source is less than 2.5, that person is a non-creamy. So a parents who is having 100 crores income from agriculture or tens of crores from working in a multinational, where is the requirement to have income from other source? Who will have income from other source? A man who is working at the margin. Suppose I am earning 10,000 a month. Okay, I am unable to meet my 2 ends meet. I need 25,000. I'll try to go from work from some other source, whether I can get some more money. If I am earning in tens of crores per month, will I go for other source? Then is this explanation not a little absurd? Yes, Mr. Bora. Don't you think logically it is little absurd? Will you ever go? Suppose from tomorrow, Mr. Bora is earning tens of crores every month. Will you go to do some other work? Will you ever conceive of, think of going for some other work? Then it doesn't matter how much you are earning from the other work. Something somewhere wrong somewhere. Maybe I have not read the whole thing.
my lord, in that the category is given, my lord.
Doesn't matter
Petitioners,
categories.
petitioner belongs to class 3 category. So her income.
Categories doesn't matter. It's a creamy and non-creamy. One is having enjoying the cream, one is enjoying only the water that remains in that pot. The cream is coming from that source. That means the considered person is drinking only the water, not the cream. Is it? Can you conceive of it? Those curd pots, have you noticed? Bottom layer is always water and the top is full of cream. If the pot comes from so-and-so place, even if you eat the cream, it will be considered to be water. Mr. Chaudhary, we are little apologetic to you. We had to bring you back. One intriguing situation has come and I have to take a call by tomorrow. That's why we requested. Otherwise, we'd have. Please come to page 30 of that one. Before that, come to page 27. Clarification regarding creamy layer amongst OBC. Okay. Then come to page 30. I don't know what is the scope of the explanation. Income from salaries or income from agricultural land shall not be clubbed. Okay, this is the question. Now come to page 31, para 10. With regard to clause 10 of para 4, it is clarified that while applying the income wealth test to determine creamy layer status of any candidate, as given in category 4 of the schedule to the OM, Category 4 schedule. Okay,
Category 6.
Something is there. Income from the salaries and income from agricultural land shall not be taken into account. Then you say, it means that if income from salary of parents of any candidate is more than 2.5, that time it was 2.5, now it is 8. Income from agricultural land is more than 2.5, but income from other source is less than 2.5. Candidates shall not be treated to be falling in creamy. Very well. Take the example of a rich farmer of Punjab and Haryana who earns in hundreds of crores.
Not income.
No, entirely. This is the difficulty. Another parents who is working in a multinational getting tens of crores of rupees per month salary. It is there.
That is income.
But
Agriculture.
no, but they don't have any other source of income that is less than 8 lakhs. Then they will be shall not be treated to be in the criminal layer, means they are non-criminal layer. Have you got it?
Yes.
So a man with tens of crores of salary, a man with hundreds of crores of agriculture income, but he has no other income, but his income from other source is less than this one, he is a non-criminal. Is it the right way the central government is looking at the issue? Or there is something wrong in it?
That, my lord, you can go to category 6, my lord.
What is category 3?
Category 6, my lord.
What is category 6?
Category 6.
Where do you get that category 6?
Page 29.
29.
29. No, 29 are only questions. Like 30, question number 10. This 6 is only a question. It is not a category. Do you have some complete document? I think the
Yes,
one
but it in another case.
what is category
6? Income wealth test. I'm just reading out. Sons and daughters of persons having gross annual income of rupees 1 lakh or above, or possessing wealth above the exemption limit as prescribed in the Wealth Tax Act for a period of 3 consecutive years.
Item 32.
30 page number.
Schedule is at page 61, my lord. That is
30, 55.
Page 61, my lord.
61.
Yes, my lord.
No. Sons and daughters of person having gross annual income of 10 lakhs or above, or possessing wealth above. So, a man having a 1 crore per month income will be a person having gross annual income over 10 lakhs. He suits. Okay. In case of parents are non-IT SSCs,
Page 61. No, it can be.
Mr. Chaudhary, will have to take it up tomorrow, and you also have to ask someone.
I just
This is a part of the recommendation. Otherwise, lordship, there page 55. My lord, my page item 32. Item 32. It is a recommendation.
32 page 55 to the option.
32, I am the petition.
55, huh? Property owners, agriculture holding, plantation, income, this explanation, income from salary or agriculture shall not be clubbed. Shall not be clubbed. Okay. And now the expression shall not be taken into account. Does it not have the same meaning? Does it have the same meaning? See, one example I asked Mr. Saikia. He's having 5 rupees in his left pocket, 5 rupees in his right pocket. I ask him a question. Should it be clubbed? Meaning they have 5 plus 5, 10. Answer given is none of the pockets have to be looked into. This is the meaning it is coming. Don't take look at my left pocket of 5 rupees. Don't take a look at my right pocket of 5 rupees. Whereas the question is whether it is 5 and 5 to be clubbed and made it to be 10. Somewhere something is missing, Mr. Chaudhary. Or else these answers are given in a very, very circumscribed situation. And the meaning now sought to be given in a more generalized way. And we can't conceive of a situation if the parents have income in crores from salary. Parents have income in hundreds of crores from agriculture income. It is possible. Agriculture is so tea garden, everything is, many things are agriculture, those huge farms. But you don't have any income from other source, or your income other source is less than rupees 2.5 lakhs or 8 lakhs as of now. You will be a non-creamy layer. And tell me which man having salary of crores of rupees and which man having agriculture income of hundreds of crores rupees will conceive of the idea of having income from any other source. Who will have? A man who is unable to meet his 2 ends meet from his regular income. He may think of income from other source, let me work some more. But by virtue of page 31, that 1 crore salary man is also a non-creamy layer. And this is what the petitioners are relying on now. Saying that, yes, we want a direction. In this instant case, the salary income of the parents of this petitioner is 11 lakhs. From one issue raised is that 8 lakhs was fixed in the year 2017, whereas there is a requirement of review every 3 years. This has not been done. Now we cannot do it. It will be in 2 stages. We'll ask the central government to review. You'll give your reply. Then we'll send back deputy commissioner. Now the reviewed upper limit is beyond the country. Medical admission by tomorrow, decision has to be there. It will become infectious. Alternative argument is page 31. The income from salary is not to be taken into account, and my parents' income is only from salary. So, and I have no other income from any other source. And even if I have, it is less than 8 lakhs, so I am non-creamy. This is the argument of Madam Saikia. Yeah, Chaudhary. How do you answer this? And that is based entirely on page 31. And it will have a severe implication because once we declare judicially.
No, the implication will be.
Tomorrow the huge farmer will come. I am non-creamy layer. High Court judgment. This is the reason why we requested your presence, even although it was little inconvenient for you.
No,
Please take it up.
Lordship is taking
Will
it
the
up
list the matter tomorrow again? But tomorrow is the last day. We'll have to pass some order.
Yes.
Either I dismiss the plea or I allow the plea.
Lordship.
Something has to be done by tomorrow.
I will. I'll take it.
And this is given by some Verma, Deputy Secretary, or in the
KG Verma.
No, this page 31 is given by 33 KG Verma, Deputy Secretary, Government of India.
This is quite old.
Minister of Personnel, Public Grievance. And mind you, this is dated 2004.
Yes.
It's about almost a 20-year-old document. And if you have something, I think immediately a further clarification will have to be issued.
Lordship.
Superseding this one, because we are bound to decide it by tomorrow.
Lordship.
We take up in the second half, so that at least some reading time is there.
Yes.
Mm.
One page, if I can place before your lordship, page number 103. Page number 100.
Of your item.
Item 32.
103. What is it? Class.
Item 32.
What is 32?
103, my lord. So that is item 32.
Yes, we have already referred to it. We know.
Paragraph 7, my lord.
Mr. Borough, you have already referred to it in your when we heard your matter on in the motion. Mr. Also take note of that para 7, page 103 of the other item. Please give Mr. Akidi Chaudhary a copy of both the petitions. This is another deputy secretary. Now it is Mr. Sandeep Saxena. Ask Mr. Sandeep Saxena why he feels so. Give one copy to your petition. Give one copy so that he can come back. Will the one statement in affidavit of one Sandeep Saxena make it happen in that manner?
Tomorrow may not be possible.
No, then we can't decide this petition. 30 is Saturday, we are not sitting. 30 is the last day. And on this, we required who appeared the other day? Mr. Gogoi, you appeared. For the central government the other day. Somebody else appeared. We have put this question, Mr. Chaudhary, but 2 days have been consumed where we don't have the answers.
Lordship, it was not reviewed. Lordship had not put the query. That's why I am not.
No, this was the query we put.
Lordship directly asked the DSJ to present here. So Lordship, we are.
To whom to remain present? Whom do we require to remain present?
No, Lordship has directed us to call DSJ.
Today? Not today. 2 days earlier also we heard this matter.
Yesterday I have appeared one matter. Lordship has directed us to obtain instruction whether it was reviewed or not.
And only on review.
Reviewed or not. And Lordship, the answer is that Lordship.
It was not reviewed, we know.
It is not reviewed and there is no any.
On 27/9 we heard this because that the argument was only on review. Yeah, Mr. Govind, it was only on review. Today the second argument is raised. And Mr. Borua, he raised this issue on?
My lord, I moved it on 28/8, my lord. 28/8, my lord, 2023.
28/8, yes.
21/9.
And that day also we put this question.
And 7/9, my lord, my learned friend wanted to file affidavit
So,
on behalf of Deputy Commissioner.
so we are. So we required that is the Deputy Commissioner, because Deputy Commissioner had given such orders. So, but now it appears it is directly Deputy Commissioner relying on the central government. And for this matter, you have to make it an exception.
Yes.
Because this is the situation.
I understand.
Had it not been medical admission, we had given you in
Yes.
any amount of time you would have required from this.
I'll try to.
Why the two deputy secretaries, one in 2004 and the one filing affidavit now, feel that income from salary and income from agriculture should be excluded to determine creamy layer? Then what remains? That means only the son of an industrialist will be a creamy person. If I get it from agriculture, no. If I get it from income, no. irrespective of what is my income. If that is the standard the central government tell us, we'll accept it without no difficulty. Because these are all policy decisions. It is yes, maybe also.
As per the last affidavit which was filed by the central government, Lordship, it was on the basis of the category of the class of the post, Lordship. As per the OM, Lordship, if the person is the class 1 category, Lordship, then he is not within the ambit, Lordship. He will never get. He will never get, Lordship. Even
So suppose we take your argument, the man is of a very, very low class. Who makes these classes?
that part,
No one makes.
Lordship.
But his income is very high.
Lordship.
And agriculture, who makes him the class? His income is very, very high. But we deem that he is under category 6.
Lordship is very correct. Otherwise,
So you earn infinite amount of income, but you are still.
But Lordship, the scheme which was provided, Lordship, is per class. Even Lordship, if the both the parents class 2.
So give us the concrete reply tomorrow.
Lordship.
And if you have any, we'll accept your oral submissions itself because time is too less for any affidavit and all. But with justification.
Yes.
Not that is the view of one man here and there.
Yeah, within half an hour. Yeah.
Or else, if then again there is a conflict. If the category of employee, by virtue of being categorized, is deemed to be earning a low income, then by virtue of his low income, he will be below 8 lakhs. You don't have to go for all these explanations. But if by virtue of his categorization, his income is more, then that categorization itself doesn't satisfy Article 14.
As per their earlier affidavit,
That categorization will be arbitrary without any rational access with the object at hand. Both ways you are, it will be unacceptable.
As per the category.
That's what Mr. Gogoi. If the category is based on income and the income is less than 8 lakhs as of now, then you don't need this clarification. Anyway, you are less than 8. If the categorization is not based on income, then that categorization violates Article 14.
It is not based on the income. It is based on the Lordship position of the post.
Position.
Position.
So not on money.
Not on money, Lordship.
So, son of a father who society feels holding a very high position, he will be creamy. Doesn't matter how much money he has in his pocket.
As far as service,
A son of a father who society believes is not in a very high position, you have hundreds of crores, doesn't matter. Then you are, is that the,
only the
and now who will determine the position?
Is the my submission is
No, who will determine the position now?
That is as per the category of the post of the central government. Class 1 category, class 2 category, Lordship. Even Lordship, the persons who have the class 3 category.
So this means this is not universally acceptable. It is only in respect of those employees of the central government who are already categorized. So it will not be applicable to others.
You can also there is a provision.
And number one, and which employee of a central government also has agriculture income? He is an employee. So if I accept your explanation, suppose I'm a rich farmer and also have a little bit of education, I'll go and have myself one low-lying central government job. Okay. Fit into category 6 and enjoy my hundreds of crores of income. But I'll be out.
As per that, it will be out.
And another farmer who is unable to procure a job, he'll be in.
As per the
So now the
agriculture income, he will.
So now the race will be get hold of a low-lying job in the central government.
we also not agree, but otherwise, Lordship, the fact is that.
Mr. Chaudhary, I think it requires some kind of deeper thought on to all this, I think. So is it the reason because sometimes we notice some people in the society who is otherwise financially very, very rich, but some people are holding an odd job, government job here and there. Sometimes you wonder why he is doing this job. Suppose a man with a good family background, having a huge business family, maybe a good farming or good something there, he will be holding a very, very low-lying post, maybe a grade 4 also. There are people. Is it for this purpose? That he will come into category 6 and I'll get the...
No, Lordship, that much foresight he may not have. Whether children can go to medical college.
Then, so let me get a category 6 job first. Enjoy my wealth to the maximum possible. Otherwise, my children will get a seat in the medical college. These are all, we are pointing out the various absurdities that we have noticed. That's all.
The reasoning is absurd, otherwise, Lordship, is the real fact.
Get something.
Flush.
Because Madam Chaudhary's case is little borderline. Her client's parents has a income marginally more than rupees 8 lakhs. But the DC had taken a technical view, it is more than 8 lakhs, you are out. Her client neither belongs to any huge crores category or anything.
Even Lordship, after going to the death, he says that he's a category class 3 officer. If class 3 officers, then we go by the affidavit filed by the central government, then she will Lordship get the benefit because she is the class 3 officer. Even income is also higher, then she will not be in that.
She will still be non-creamy.
Lordship?
Her client will still be non-creamy.
Non-creamy, NCL, she will be NCL. Lordship.
Why?
Because she is service the category 3 Lordship.
So category 3, even if your income is more, it doesn't matter.
More doesn't matter. As per the affidavit by the central government. Even Lordship, one parent is the class 2 officer and other is the class 3 officer, then also Lordship, she is non-criminal. Or if both the parents is class 2 officer, then she will not get the benefit. And even Lordship, single parent is the class 1 officer, then she will not get the benefit.
Then what about agriculture?
Agricultural income, Lordship, as per the OM, Lordship, the income should not be clubbed together, Lordship.
But clarification says take out the agriculture income. Don't consider it at all.
2004, after the 2000 amendment.
Nothing is there.
There is no amendment. Otherwise, Lordship, my senior sister's client, Lordship, she will, as per the affidavit, she will get.
Okay, we remain tomorrow.
She will get benefit. If the class is 3, Lordship, class is 3, Lordship, she will get benefit. Then income is not a matter, Lordship.
My lord, my client, my petitioner is LP school teacher, my lord, and her husband does not work. She is the only bread earner.
But again, Mr. Gugoi, category 1, 2, 3 of central government and class 1, 2, 3, and 4 of the government of Assam are different.
Lordship, that was also
Government of Assam 4 is a grade 4 employee. He will be a peon.
If Lordship permit,
And central government grade 4 will be something, category 4 will be something different.
if Lordship permit, I can just read one paragraph, Lordship.
You read at home, tell me tomorrow.
Lordship, the other petitioners also, Lordship, in the state of Assam, Lordship, then the central government clarified that one of the parents is a teacher in the high secondary school, the class 2 officer in the state government of Assam, and mother is a class 3 officer, so she is entitled for a non-criminal certificate. That is the explanation of the central government.
Yes, okay, we'll follow it. But otherwise, we are on this page 31. 31, we are not very happy. Hmm? No, like, can suppose we issue a direction, DC should have time to. Mr. Thoduri, we'll have to take up these two matters in view of Mr. Gogoi's submission in the morning itself. Suppose we issue some positive direction, the DC will need some time to issue the certificates. And regarding your page 31, we'll hear you in the second half.
Yes. Lordship, first up, I will be at around 11 o'clock.
Okay, a little bit here and there.
Yes.
And 30 is a fifth Saturday. DC can even issue the certificate on that day also.
But my lord, after that online counseling and that process or.
You'll have to do it. You'll have to do it. What to do? See, have you ever noticed me sitting till 5 o'clock? Today, why we are required to sit till 5 o'clock? I'm already always over by long time back. We'll take note of everything.